Eddie, did you happen to listen to that 14-minute audio I sent you?
When did you
To the
send it,
group?
Jane?
I sent it yesterday, the day before. It was the cross examination, just the part where I was cross examining the officer for the speeding trial, where I was trying to get the statute, where I was trying to get the evidence into the record, but was not successful in doing so. We're
Well,
trying to
I see the email for it, but no, I haven't read it yet. I just got it
get.
yesterday.
You don't have to read it. You can just hit
Well, I
play.
didn't listen to it. I've got a puppy here for training, so I've been kind of busy just with that puppy because we're outside every couple of hours, and I'm
Oh,
baked when I'm done. So I come in, I take a cold shower, and I sit here in front of the fan until it's time to go out again. I ain't looked at this damn computer hardly at all.
yeah. Well, yeah, you don't have, it doesn't even open up a media player. Just if you hit play right there on the email, it'll play. Mm. Anyway, and that's how I try to get to have the officer read the statute, but I was not successful in doing so.
Well, how did you get the statute into the case to begin with?
I didn't, but see, I did. I filed a motion before the hearing and asked the judge to make available the references like the Black's Law, the Texas Penal Code, and I gave her the specific, the 103, and also the Texas Transportation Code 545, 351, 352, and also 201.904. I asked her to have it available for the, they would please provide it for the court. So to me, that sounds like okay, but she says I didn't. Yeah, I'm not providing evidence for you. Is what she said. I'm not here to provide evidence for you. And I said it's not evidence. It's statute. But
But
anyway,
you're trying to use it that way, Jane.
yeah, I know, but still,
This is why, okay, everybody listen up to this and listen very carefully. If you want to directly submit a statute into the record in a court as evidence of anything, then you need to get a certified copy of the statute from the Secretary of State. Period. Every public record with an official seal on it is self-authenticating. They can be introduced as is by anyone. So if you want to try to get the statute in that way, then pay the $16 to the Secretary of State to get certified copies of each of the statutes you need. But you better be complete about what you get. If you get the statutes, make sure you also get the definitions that statute uses. So whatever other sections relate to that, such as Chapter 311, for instance, okay? And Chapter 541, for instance. You would have to have all of that in order to encompass all the specific definitions relevant to the statute. Or you would have to have the statute in the section you're talking about or in the chapter you're talking about that has a local definition for it. The only other way around that is to buy a book that's got the statutes. Buy a copy of the Code of Criminal Procedure. Buy a copy of the Transportation Code. Or get the Secretary of State to send you a certified electronic copy of the Transportation Code. If you get a certified copy of the original bill and the current statutes, it's going to cost you $32 or something, but you'll have it. And you can use it anytime.
until it's outdated, right?
Until something in it changes, yeah.
And that's every year.
But then you need to either go back and request a new copy of everything, or you need to request a copy of the piece that changed.
Well, so that judge in that speeding trial would not take judicial notice of Texas Admin Code 4. The
What do you
relevant.
mean he wouldn't take notice of it?
He wouldn't take notice of it. She says, I don't know what that is, and I'm not going to look it up, and I don't think it's relative to the case. Now I told her it was, and that's where
Then you should have immediately moved for her disqualification for refusal to apply the law to the facts.
yeah, I should have, since she already had found me in contempt.
Doesn't matter if she finds you in contempt, Jane. You can go back after her for doing that bullshit later when she had no authority to be doing it in the first place. And if a judge throws you in jail for contempt because you asked her to disqualify or recuse herself for failing to apply the law in its totality, then that's a judge that doesn't do to be a judge in the first place.
That's really the hateful little thing. Worse than me.
All right, let's assume we got everybody we're going to get for the moment, and let's get this on the road. All right, now, before we start anything else, there is a video I want you guys to see. I want you to pay very close attention to what this attorney says about how to read a statute. Okay? Listen, pay close attention here. This is everything I've been trying to tell you guys about how to read and dissect these statutes. It's the same exercise. It meshes well with the exercise I gave you on dissecting the ordinance. Okay? So, let me see if everybody can see this.
Now, I hate to do this to him. I hate to make this video, but Officer Tatum is a boot-licking moron, apparently.
Next, Tatum thinks that the officers used a proportionate amount of force for the situation, because he's a bootlicking moron.
If you don't know what you're talking about, don't make a video about Brandon Tatum. That's it. Put your bias.
Now, in case y'all don't know, the guy on the left, the white guy, is the one that does the Lackluster videos. Okay? The guy on the right is Officer Brandon Tatum, who does his own podcast, which is what he's on right there. He is an ex-cop, and he talks from a cop experience. But I will tell you, in this case, he is completely dead wrong. And Lackluster is calling him out on it.
These aside, put your anti-police rhetoric aside, do some research before you decide to make a video calling me a bootlicker and all kind of other stuff when you have no idea what you're talking about according to the law. You have no idea what you're talking about according to police interactions. You have no idea what you're talking about according to what you claimed that I said and the positions that you said I took and didn't take.
All right, guys, we are heating up. We are talking today about two heavyweights going at it. We have the Officer Tatum. Y'all know him, a huge Goliath in the space. He has over 3 million subscribers, a big dog. But then you have another YouTuber, a man named Lackluster. He also has over 1 million subscribers. Lackluster has called Officer Tatum out over this whole JSO officer viral video. Lackluster calls Officer Tatum a moron, calls him a bootlicker. Now Officer Tatum has responded back. What I am going to do is review this video, and I'm going to look at one thing specifically. I'll be honest with you, they talk about a lot of different issues, and if I try to cover them all, I'd be here all day. So I'm only going to cover one. Maybe in future videos, I'll pick up some more issues and I'll decide who is right and wrong. Again, I am the lead attorney, practice law down here in Atlanta over 20 years.
Now, just FYI, what he's going to go over is exactly what I want you to pay attention to. Because the one thing he's going to talk about is the linchpin key to whether or not the stop that was done in the video Lackluster and Tatum are arguing over, that's the statute governing the interaction that occurred in that video. So y'all pay attention.
I've handled countless criminal cases, so I've got a perspective on this. Now, Lackluster and Officer Tatum are arguing back and forth about numerous issues, but I'm only going to pick up one today. Today, we are only going to talk about the rain issue. Was the officer correct in pulling over the driver because he didn't have his headlights on?
Is there a reason that you're pulling me over?
Yeah, absolutely. There's a reason why I'm pulling you over. For one thing, inclement weather, you don't have your lights on.
Now, it needs to be said that the officer had a couple of more reasons why he pulled the driver over. But we are just going to focus on the headlight issue and the rain issue. Was the driver required to have his headlights on because of the rain? Officer Tatum and Lackluster can't agree on this point, and I'll be honest with you, a lot of you can't agree either. I did a video on this recently, and I got so many comments about the dang rain. I mean, just look at what you guys are sending me 44 minutes ago. Am I the only one that sees raindrops all over the dude's car? car 55 minutes ago. I see raindrops. If it wasn't raining, why are there raindrops? Dude, it was clearly raining. Come on, Lee. There were raindrops everywhere. It's rain, rain, rain. It's 100% raining. The beautiful Ricky says, Lee, I usually agree with you, but you can see the raindrops. Guys, I tell you, I got hundreds and hundreds of comments. There's literally rain on the car. Everybody's talking about this rain. So who is right, Lackluster or Officer Tatum? The boot.
Now, the other thing to understand is a lot of those people in those comments turned out to be attorneys. A lot of the people telling this guy he doesn't know what he's talking about in those comments, because I looked up, I did some research of my own on some of the people in those comments. A lot of them are attorneys. So this is going to prove a point to you that I've been trying to make for a while.
Liquor. By the end of this video, you will know decisively who is right and who is wrong in this debate. And it's very important for me to tell you that you're not going to know who's right or wrong just because I told you. You are going to know who's right and who's wrong because you critically thought for yourself. So here's what we're going to do. It is your first day in law school. You are sitting in my criminal law class. I am your professor, Professor Lead. Today we're going to talk about this case and whether the officer was allowed to pull the driver over because he didn't have his headlights on. Again, there are a lot of other issues that we can talk about, but I don't want to make this video too long. So, was the officer allowed to pull the driver over because the officer saw that he didn't have his headlights on? That's the question that I'm asking you. And you, it's your first day of law school, you say, well, I don't know. How am I supposed to figure it out? Well, I'll tell you, young student, if you have a
Quick, before he gives us the answer, how do you find out what the officer can and cannot do relative to this stop?
Break the statute down.
Say again?
Break it down.
I don't know what kind of mic you're using, but you start talking and then suddenly you cut completely out.
You break it down.
Yes, you break it down, but in order to break it down, what's the first thing you have to do with it?
Read it.
Read it. There you go. You always start by reading the actual statute. And then you read around the actual statute. And then you read the definitions that govern the statute. You start here, and then you expand out until you have a complete picture of what that statute really means. You get it?
Yes, sir.
It's not just reading the statute. It's reading the entire body of law that interacts with that statute. And there is almost always more than one.
Question about the legality of something. The first place you go to is the law. You go to the state statute. All right, here is.
Everybody see the words and read them.
That kind of matches the Texas lighted lamps.
Okay. The only thing you need to look at is 316.217, when lighted lamps are required. Number 1 and section B. That's where we start. Number 1, B. Now we know A. Half an hour before sunset to half an hour after sunrise. Okay? That's the twilight hours. So, at twilight till the next day at twilight, or whatever you want to call it in the morning light, you have to have your headlights on in the dark or low visibility, right?
Yes.
That's pretty much standard everywhere. So, B is the one, however, that can be slightly varying depending upon the wording used in the statute. So, 316.217, section 1B. Every vehicle operated upon a highway within this state shall display lighted lamps and illuminating devices as herein respectively required for different classes of vehicles, subject to exceptions with respect to parked vehicles, under the following conditions. Subsection B, during any rain, smoke, or fog. Okay? Remember 1, remember B.
The state statute right here, the Florida Senate, the Florida statutes, when lighted lamps are required. All right, this is going to explain to us when you have to have your headlights on. If the officer saw that the driver did not have his headlights on when required, then the officer was correct in pulling him over for this violation. Let's read it. It says, every vehicle operated on a highway within the state shall display lighted lamps and illuminated devices as herein respectively required. Okay, number one, at any time from sunset to sunrise, so basically at nighttime in the twilight hours. But here is where we get into the thick of things. You are required to have your headlights on during any rain, smoke, or fog. So if I ask you, young student of mine, when in Florida are you required to have your headlights on relevant to this specific case, the answer is during any rain, smoke, or fog. You got that? Rain, smoke, or fog. That's it. Now you guys may say, wow, being a lawyer is pretty easy. I know what rain means, I know what smoke means, and I know what fog means, right? Well, I got you.
Anyway, what I was going to say is, what he's about to ask you, I'm going to ask you first. And that is, as he said, you all know what rain, you think you know what rain means, you think you know what smoke means, you think you know what fog means. Okay? Now the question is what is the operative word in subsection B of the Florida statute? What is the word that controls all other words in subsection B?
During.
Put it up there.
Lamps.
The word lamps is not in subsection B.
During.
I didn't see.
No, I'm sorry.
She's correct.
During, yeah.
During. What does during mean?
That it's happening.
As it's occurring.
That it's actually occurring. It can't be before. It can't be after. It has to be during. Right? So it's during any rain, smoke, or fog. Rain must be actively falling out of the sky on you in order for you to have to put, and your vehicle, in order for you to have to use your lights. You must be traveling through smoke or fog when you are required to use your lights. During your time in the smoke or fog or rain is when you have to use your lights. Everybody clear on that?
Yeah.
All right.
Important word when we analyze this particular situation is not rain, is not smoke, and it's not fog. What's the most important word? It's during. You see here, guys, this during here, this is the operative word. This state statute, honestly, is very specific. It doesn't say before it's raining. It doesn't say after it's raining. It says during the rain. So what does that mean? It means that the officer has to initiate the traffic stop during the rain. The officer has to pull this driver over while it's raining. The pulling over of the driver and the rain needs to occur simultaneously. Is that clear to you? And since you're a first-year law student, it's your first day of class, you might say, well, that's not really what they meant, right? They didn't mean during. No. The United States Supreme Court, all the way down to all the lower courts, have always said that the legislature means exactly what they've said. If the legislature would have wanted to write this law to say, before the rain, then
until the courts themselves decide they don't like the way the legislature wrote it and interpret it completely differently.
Yeah.
Yeah, that happens a lot.
the legislature could have done that. If the legislature wanted to say 30 minutes after the rain or an hour after the rain, the legislator could have wrote that in the statute. The legislature did neither, however. The legislature said during. These state legislators are all adults, probably half of them are attorneys, so they know how to use their words well, and they all said during. What does during mean in this context? It means two events occurring simultaneously. The pulling over of the driver and the rain. We got that? We're on the same page? Now you know how to analyze this case legally. Now let's go to the facts of this case. Was it raining? Here we have the driver's car and we can clearly see water droplets. Now let me ask you, law student, thinking critically.
All right, Jane and everybody else, everything he's about to say conforms perfectly with how I want you to look at this ordinance relative to the facts of your case. Okay? Everything he's about to tell you about how to analyze the facts relative to the legal requirement, that's what I want you to learn to do to critically think. Okay? That's what he's about to tell you. So let me back it up just a smidge here.
We see water droplets. Now, let me ask you, law student, thinking critically, if there are water droplets on a car, does it necessarily mean that it's raining? This is easy for you, even though it's your first day. Obviously, the answer is no. Water.
And that is step one in the analysis of Jane's case. Just because you're feeding an animal outdoors, does that necessarily mean that a public health or safety danger arose? No. Does that mean that 11 or more adult animals congregated there? No. Does it mean that automatically that there was private or public property damage? No. That's the part I want you to think about, Jane. The first two steps, being the owner of the animal or feeding the animal, neither of those automatically result in any of the three things that the city is calling an offense.
Right.
Get it?
Yeah.
All right.
Same with my headlamp situation.
Same
Just
thing with
because
that. That's correct.
Water droplets can be on a car for numerous reasons. Water droplets could be on a car because it rained 15 minutes ago. Water can be on a car because the car got washed. Water.
Okay, now once again, he's telling you here's all these alternative explanations for why something does exist that can be misconstrued. So, Jane, relative to your case, the fact that there might have been a rabid animal somewhere in the neighborhood, but not at your food bowl, would not be indicative that your actions is what attracted the rabid animal to the neighborhood, right?
Mm-hmm. Right.
Okay? Same thing if it was just a nuisance animal, a dog digging through trash, or a bunch of raccoons that came and raided trash cans. That's not indicative that you're feeding two cats in front of your house drew those raccoons or those dogs into the neighborhood to do what they did, right?
Right.
So again, critically thinking, they cannot tie A and B to C, D, or E, or E 1, 2, 3. They can't tie it to any of those.
To question those things, right? Have you not seen any animal anywhere on the property, right? I mean, as far as, they haven't witnessed any animal. It's still okay to ask those questions, right?
Well, no, don't ask a question that gives them an opportunity to make you look stupid. The video clearly shows there's animals. So you need to make sure that the way you word your question can't be contradicted by the video or create an inference that contradicts you from the video. For instance, if they do play the video and jump up and say, look, there's animals right there.
I meant to say,
You need to have asked your questions in a way that made it, if the video is not introduced before you cross-examine whoever you're cross-examining. But you have to ask your questions in a way that can't be contradicted by the video. So saying you don't see any animals, and then they show animals in the video pointed at your house, makes it look like you're misconstruing the facts. When in fact, the correct way to say it is, you have a video that shows 2 or 3 cats, but it doesn't show any of those animals eating out of the bowls in my front yard, does it? That's how you would word the question. Not in a way that can be swung around to hit you on the other side of your face when you throw it.
But it does show that.
It does show what, Jane?
The video does show 2 cats eating out of
Okay,
plates.
then what is the correct way to ask the question?
Well, in regards to, okay.
In regards to the 3 things that they consider a public nuisance that they're trying to charge you with, what's the correct way to ask the question? You have to ask a question that disproves all 3 of those things. So give me a question for each one.
Rebecca, why don't you do this?
Well, did you get a chance to see the thing that I submitted to Eddie?
No, I haven't, but I've got the questions. What I think but I don't have. He put me on the spot again, so no, I'm not ready.
All right.
It's exactly the same way it's going to be in court, though, too.
Yeah.
Jane, you got to quit looking at this like you're being put on the spot. You're going to be on the spot in court whether you like it or not.
No, so you're saying 3 questions of each of the different elements, like danger, public safety?
No, you have to, in order to show that they can't prove any of the 3 nuisances, you've got to have at least one question that disproves the elements of that specific piece, right?
And so right now
you have to have a question that negates danger to public health and welfare. You have to have a question that negates property damage, public or private. You have to have a question that negates 11 or more adult animals congregated simultaneously in one place.
I have all those, but what witness am I asking these to right now?
Well, it doesn't matter. The question is do you ask the question correctly, whoever it's directed at?
Okay, so Ms. Smith, how many animals do you see that in the video? There's not, do you see more
You're
than...
assuming that they're still looking at the video, right?
Okay, so, well, yeah, okay. You provided a video to the animal control officer that depicted how many animals in the video? I don't know how to say that. Let me see.
11 or more adult animals.
Yeah. Did the video that you provided to the animal control depict 11 or more animals gathered around the food bowl? And she would say no. And I would say, did the video evidence show that the animals were destroying public or private property by, clawing and bark off the tree or chewing up a lawn or anything like that? She would say no.
Well, the simple way to ask that is, do you have any evidence for the court showing that there was damage to public, private, or property that was directly due to these animals?
Okay. And, let's see. Did you personally witness or do you observe any dangerous behavior on behalf of...
No. Do not ask an open-ended question like that.
Okay,
do not.
Okay.
A leading question, Jane. Always a leading question.
Okay. You cannot...
and it needs to be focused specifically. There's nothing in the statute that says, or in the ordinance that says a damn thing about dangerous animals. So stop throwing out words that are not in the ordinance. Stick to the 3 sections at the bottom that deal with the nuisance part. Use the words that are already there. Don't add to it, because that's what they're going to try to do.
Does the video provide any evidence? The video does not provide any evidence that displays a danger to public safety, does it?
The video doesn't. The video does not show what?
Does not show any activity that would endanger the public health or safety.
Okay. You know how videos work, right?
Well, yeah.
You know that they can be displayed on a screen, right?
Yes.
You know they can be stopped, just like the one I've got on the screen in front of you. They can stop, just like this. So you can sit right there and stare at the same frame of that video for as long as you want, right?
Yes.
Okay. So, if you stop the video at the point where the cats are on display, and that's all it shows is that same view the whole time, right? Doesn't change.
Yes.
Okay. So, Ms. Smith, can you please count the number of animals in this picture?
Okay. 3.
Now, Ms. Smith, how many of those animals are actually congregated in one location in this video?
None.
Well, you said 2 of them were at the food. Did
Yeah,
you not?
but there's 2 different plates, and they're not in exact same locations.
Well, again, how close together are they, Jane?
About 3 maybe.
Right, and there's the reason why we're arguing about there's no definition of location in the ordinance that tells you how big an area location encompasses.
Right.
Okay? But that's neither here nor there. The fact is that at most they can say there's only 2 gathered together because it's all the video shows, right?
Yes, that are eating.
So there is nothing in this video that shows 11 or more adult animals congregated at the same time at any location shown in this video, is there?
No.
And you have never seen a gathering of 11 or more adult animals in one location on my property at any time, have you?
No, I don't recall.
Well, you obviously have a problem with it if there was, because you took a picture of 3 and only 2 of them were at my house. And yet you don't have any evidence of there ever being more before you filed a complaint about it. Isn't that correct?
I don't know. Yes.
So I'll ask again, and please, yes or no. Do you have any evidence of any kind proving that 11 or more adult animals have ever congregated simultaneously in one location on my property?
No.
Ding, ding, ding. E3 is dead in the water, Jane. There is absolutely nowhere for the city attorney to go with that.
Okay, that's one of the 3.
Well, we're still looking at the video, aren't we?
Mm-hmm.
All right. Now, as we can see, there's one cat, which I don't know who it belongs to, but there's a cat sitting on a car.
No, it's not on the car. It's on sitting on the
whatever
car.
the fuck he's on, Jane.
All right.
Okay. And there's 2 that are over in front of my house. Can you please identify the animal that was destroying your personal property?
I didn't say that they were destroying personal property.
And you didn't make any such allegation in your complaint, did you? Or in the statement you signed, did you?
No.
In fact, you didn't allege that anything at all occurred in your complaint other than you just didn't like what was happening.
That she was leaving food out for the cats.
Which you don't like, right?
No, I don't like.
And yet there's nothing in the ordinance that says feeding an animal outdoors all by itself is an offense. Did you know that?
What are we here for then?
Well, because you signed an affidavit and Officer Idiot took it to heart and wrote a citation on it. That's why we're here.
Well, but I don't tell them what to do. They do an offense if they want to. You know.
No, but you're the reason they keep showing up on my property and issuing me citations, because you keep making false reports that something's going wrong and is illegal. Don't you?
Well, she needs to stop feeding the animals outdoors.
That's your opinion. But we're not here to vet your opinion against the law. The law is what the law is. If there was a law at issue here, and there isn't, because all it is a city ordinance that has nothing to do with this case, because nothing in the ordinance ever occurred. And they're trying to use it on my private property instead of city property. So again, you just like being a vindictive, hateful neighbor that doesn't like your other neighbor, right?
Well, I don't like her, that's for sure.
There you go. All right. So now we have E1, E2 and E3 completely obliterated, Jane. So what does that leave us with? Public health and safety, right? Mm-hmm. Danger to public health and safety. Right?
Mm-hmm.
Okay. Now, Miss Smith, can you please identify the animal in this video that attacked you?
I did not say that an animal attacked me.
In fact, you've never made a complaint that any animal attacked you, right?
No.
And you never made a complaint that any animal that would have attacked you belonged to Miss Lynch, correct?
No.
You probably will in the future now that you've been given a new idea, but at least now they'll know what to expect when you file such a report. Yeah. However, considering the fact that you were never in any danger from these animals, and they've done nothing to adversely affect your safety or your welfare, you were still complaining only about the fact you didn't like it, correct?
No, they pee on my property. That's what she's gonna say. Some bullshit like that.
I don't care. The question is, you don't have any evidence that they have ever caused you any actual harm or injury in any way, correct?
Not that I brought with me.
Not that you brought with you. Do you go around the neighborhood collecting urine samples from animals?
No.
Then do you go around collecting feces from animals?
No. But
Do you get a geographic survey done of the exact location where you retrieve these specimens?
No, she doesn't retrieve them, but she does make false
Jane,
allegations.
listen to what I'm asking and why I'm asking it.
Okay.
Don't give me excuses for what you think she's going to try to wiggle out of it with. Listen to what I'm saying.
Yeah.
This is about building the cage and locking her sorry ass in it. Pay attention. So you have no evidence of any actual destruction to your property or that any feces were ever dropped on your property by an animal that you can directly prove belonged to me. Nor do you have any actual proof of where those specimens would have been retrieved from. So basically what you're testifying to is you're just a bitchy old woman with nothing better to do than harass your neighbor with false reporting, right?
Well, they pee on my Amazon packages, what she said before.
Well, then she might as well just try and sue the city or whatever because birds shit on her car.
Yeah, I know, but they really didn't. But she said that in the other trial. So
Well, again,
Yeah.
does she have any actual evidence that
No.
any of those cats peed on her packages?
no, she didn't have it then either. So
No, and she won't, because it didn't happen.
Oh,
I
no.
have never seen a cat intentionally walk up to a delivered package just to pee on it.
No, I couldn't believe she said that. She doesn't know cat very well.
Now, a dog, that's a whole different matter.
Exactly.
Anything new that shows up that he feels might be something intruding on his territory, he's going to piss on it and mark it to prove he's the better dog.
Right.
But not
May I
cat.
interject about cats? May I interject about cats just for one quick moment?
Go ahead.
My cat intentionally pissed on my husband in the middle of the night at 4:30 a.m. while he was asleep. He was mad because my husband throws stuff at him. So
Yeah.
what he did, he
Well-
peed in his lunch kit, and then he sat on top of my husband between where his legs were extended on top of the blanket. He intentionally sat down and pissed all over him.
A Siamese? Is this
Oh,
a
no.
Siamese cat?
Oh no, he's Snow Bengal.
No, I hope he didn't get a beating.
And every time my husband's lunch kit is around, if it's in his reach, he'll sit in it and piss. And he'll piss all over his clothes too.
You must not like him very much.
No.
Because my husband
Cats-
throws shit at him and he
That-
holds a grudge.
He does. Cats are extremely vindictive animals.
They are
Extremely
not.
vindictive. Yes, they are too.
They are when
I
they
used
want
to.
to be.
I used to live with a girl that had a cat, and it was a Siamese cat, and it was exactly the same way.
If
It
you're
didn't-
hateful to them, they're gonna not like you. Yeah.
I wasn't hateful. The thing is, I was very nice to the cat, but this cat had a nasty habit at 2 or 3 o'clock in the morning of getting a ball of tinfoil. That was his favorite toy in the world, was a ball of tinfoil. And he would bring it up and drop it on your face at 2 a.m. and want you to throw it. And if you wouldn't throw it, he felt it was perfectly fine to lash you across the face with his claws to wake you up to get it. So one night I threw him and his tinfoil ball down the stairs. And from that point on, we slept with the door closed and his ass stayed outside.
So please don't underestimate the vindictiveness and the long memory of my kitty cat, because he has never forgotten.
Only treat you the way that, if you have done something to them, or they sense something is not right with you. So,
All right.
otherwise, you're very loyal to me.
Now, in any case, that's basically what I'm wanting you to get out of this video. So let's finish up on watching this here.
can be on the car because the car rolled over a puddle and water splashed on the car. So just because there are water droplets on the car does not mean that it's raining. What I'm going to do is play this video, but I'm going to mute it so we can focus on the water droplets. And what I want you to look at, young student, I want you to see if there are any new droplets that you see forming on the car as the video plays. Now, everybody take a close look. I'm going to play the video. Do you see any new water droplets? If you see new water droplets, then we can assume that that's rain. If we see no new water droplets, then what does that mean? All right, let's play the video. So here is the video. It is playing. Again, I've muted it because we don't need the sound to figure out whether it's raining or not. I'll be honest with you. I'm looking at the glass. I'm looking at the molding. I'm looking at the door. I see no new water droplets. Do you guys see any new water droplets?
No.
I don't see one. We're just letting it play here. I'm going to say that it's not raining, guys. Could it have rained previously? 100%. I do believe that it was raining 5 minutes, 10 minutes, 15 minutes, 30 minutes ago. But if I'm honest with you, I saw no new water droplets forming on that car. So, young student of mine, this is the question for you. All right, you ready? During the time that the body cam video was taken, was it raining? That's your question. Now, I do need to point out that it is technically possible for the officer to have pulled the driver over and then 5, 10, 20 seconds when the officer gets up there, it stops raining. So that it was raining when the officer pulled the driver over, but it's not raining 20 seconds into the video.
Now, based upon that assertion, what do you see in the video that would show that is highly unlikely? That it only stopped raining just a few seconds ago, or just a minute or two ago.
Well, would it be the rain that's still on the car?
What about the rain that's still on the car? What about it?
It's not running down the car.
Yeah, it's not. Yeah.
Well, it's not running down the car because there's no air affecting it. So it's stationary. It's not getting moved one way or the other. So surface tension hasn't held where it is. But that's not how you're going to disprove when the rain actually stopped.
There's a lot of car.
It's what?
There's a lot of dry on that car.
There's a lot of dry area on the car. And it hasn't been raining for at least several minutes. And this guy's been traveling in his car.
Correct.
If he was stationary or the officer had just started to pull him over in the rain, right here with him slowing down and stopping, this car would be covered in running drops.
Yep.
It's not. The droplets are very sparse. They're only collected in certain areas on the car and they're gone everywhere else, indicating that the car has been moving and no new water has been accumulating on it. So that's how you would make the argument that shows that's not a plausible scenario either.
Right.
Okay? You always look at everything to try to see what will disprove the other side's case the best. And that is the best argument to make. Like, for instance, look at the rear window. The rear window only has water on the very lowest part of it. There's no water up in the middle of the window. Same thing with the front part of the driver's window. The water's only in the back corner, but there's hardly any except right up close to the mirror on the driver's window.
Yep.
All that is indicative of the car having been moving for a period of time without new rain falling on it.
Yep.
All right. Pick her back up.
It is a possibility technically, but just going on the video as we see it, I believe it is not currently raining. What did we say about the law? We said, young law student, that every vehicle operated upon a highway, every driver is required to have their headlights on during any rain, smoke, or fog. So was this driver required to have his headlights on? If the officer pulled the driver over during the rain, then yes. But if the officer pulled the driver over when it was not raining, then no. Now, when you hear all these content creators, these YouTubers talking about this issue and you don't know who's right, now you know how to think for yourself. Now you know how to legally analyze whether this driver was required to have his headlights on or not. Now, law student of mine, I'm going to give you a quick pop quiz. I am going to have you analyze some of the comments of the regular people, the people who are not in law school like you are. And I want to see if you can identify any issues with how these laymen are thinking about this case. Here's the first comment. It says the ground is wet and there are water particles on his windows. Just because it isn't currently raining doesn't negate the fact that inclement weather was and is still problematic. All right.
Okay. What did this commenter substitute for the operative word of the statute?
Inclement weather.
Inclement weather. That is correct. Okay. And the other one down here does basically the same thing. Water on the vehicles and skies are cloudy. So even if it wasn't raining in the video, it probably was raining before they started rolling. Well, again, does the statute require just that there had been rain, or does it require that there is actual rain falling?
Rain falling during.
So, both of these commenters either haven't read the law, don't understand the law, or are just utter fucking morons that want an opinion without any facts. So, let's continue.
Hey, law student of mine, do you see a problem with this argument? Let's look at this one. TLA, we can see that there is water on the vehicle and that the skies are cloudy. So even if it wasn't raining in the video, it probably was raining before they started rolling. Law student, future lawyer, do you see a problem with this comment? This is why I love the internet. This is why I love YouTube. You guys can learn to critically think in a legal manner, just as we attorneys do. No information, no knowledge is locked behind some gate. No one's gatekeeping now that we have the internet and especially all these chat GPT-4s. Now you guys know something that these regular laymen do not. All right, now let's see what Officer Tatum has to say about this. Let's see if we can spot any issues to his thinking, to his rationale, or is Lackluster wrong? Let's take a look.
You're going to hear this guy talk about it. You see people say it online. It's the most asinine and ridiculous claim. It's because they hate police and they always want the police to be wrong, so they will make up anything. It wasn't raining. Look at this video. This is fresh rain droplets still hanging onto his vehicle. If somehow it wasn't inclement weather, which means it wasn't raining at all, you wouldn't still see rain droplets on his car.
Let's stop it right there. Officer Tatum says if it wasn't inclement weather, you wouldn't see rain droplets still on his car. Now guys, I got a question for you, and I'm gonna see who are the A students and who are the B students, all right? There are two problems with what Brandon Tatum just said. He said that if it wasn't inclement weather, you still wouldn't see the rain droplets on the car. Can you identify the two problems with this statement? I'll give you 5 seconds, all right? And while you're considering it, it's very hard to get an A in law school, okay?
They, statute doesn't say inclement weather.
That's one. What's the other one? What's the other issue with what Tatum said?
That the water droplets are not.
Correct.
Could have
He's still conflating the fact that there's rain droplets still on the car with it actually being raining. Though he admits that it isn't raining, but that it had been raining. So he's contradicting himself in what he's saying to begin with. Now don't get me wrong, I like a lot of Tatum's videos, but in this case, he is thinking like a cop and not a good one. Okay? He's thinking like a cop who wants to make a traffic stop. He wants to bust a guy. Not like somebody who's thinking about what the law does or does not say and allows them to actually do. That's his problem. Okay? So given that, he's got three parts of this wrong. He's using inclement weather argument when that's not what the statute says. He's using the presence of raindrops to insinuate that it is raining or was raining when it obviously still isn't, and probably was not before the stop even was initiated, based upon what we observed on the windows and the amount of water that remains on the car and where it's located, because all that's indicative of the wind rushing past the car as it's moving to push the water to the locations it's at. So it hadn't been raining for at least a few minutes. At least a few minutes. Okay? However long this cop's been following him, probably. So, let's see what else he gets wrong.
Okay. All right. Time's up. If you got this answer, then at least you have a B. What's the problem with what he said? Let's go back and take a look.
Look at this video. This is fresh rain droplets still hanging onto his vehicle. If somehow it wasn't inclement weather, which means it wasn't raining at all, you wouldn't still see rain droplets on his car.
He said if it wasn't inclement weather, you wouldn't see raindrops on the car. What is the B answer? The B answer is, Officer Tatum, respectfully, you can see raindrops on a car when it's not raining. The rain could have stopped 5 minutes ago. It could have stopped 15 minutes ago. It could have stopped 30 minutes ago. Just because there are raindrops on a car does not mean that it's raining. If you got that answer, then I will give you a B. All right. That's the layup answer. But do you see a second problem with what he said? And let me just replay it because it's hard to catch.
If somehow it wasn't inclement weather, which means it wasn't raining at all, you wouldn't still see rain droplets on his car.
Did you catch it? Guys, I will tell you that if you are an attorney, you have to pay such close attention to every single word.
And that, ladies and gentlemen, is exactly the point to my telling you, listen to what you hear. Okay? That right there is a perfect example of why you must do that. Listen to what you are hearing. Analyze it as it goes through your ears and your brain, and you process it. That's how we separate the allegation of inclement weather versus during rain, smoke, or fog. They are not the same. Understand?
Yes, sir.
What did Officer Tatum say? He said if it wasn't inclement weather. What's the problem with that? The problem is inclement weather isn't a thing. It's nowhere in the statute. Guys, here is the complete statute that governs when your lights must be on, your headlights. Again, we see here during any rain, smoke, or fog. Do you see anything about inclement weather? As a lawyer, you have to pay attention to when people try to introduce new words, new meanings into an argument. Nowhere in here does it talk about inclement weather. In fact,
and that, Jane, is exactly why I said the question about dangerous animals is not a good question.
Okay.
Now, a danger to public health and safety, that's a question. Because that's a what do they call it? A nuisance.
That's what I would be questioning in regards to.
Yeah, but you didn't say danger to public health or safety. You said dangerous animal.
Oh, yeah. Okay, well.
Okay? That's why you must focus and think about what you're asking and not create an element that the ordinance doesn't encompass.
Well, can I say something like on the public health that are you alleging that there was an animal?
No, because that is not a what kind of question.
Okay, so then have you seen any animal that was sick or had rabies on your property?
Objection. How would the witness know? She's not a veterinarian.
Have you seen any animals that are foaming at the mouth?
Objection. How would she know if they're taking an Alka-Seltzer or was rabid? She's not a veterinarian.
Have you witnessed any animals at all on your property that appear to be sick?
Again, Jane, where does the ordinance deal with sick animals on someone else's property and tie that back to you?
The public health, I was thinking.
Again, a sick animal is not the same as did you see any of the animals that you see in this video on your property appearing to be ill? Why in the world would you ask about any animal and make it look like you're responsible for every animal?
That's what they're trying to do, but anyway, I know.
Well, there you go, which is why you shouldn't be helping them.
Yeah, don't ask any questions that's not going to help you.
Right.
Focus strictly on what's in the ordinance. Every single question needs to fixate on the upper section dealing with ownership, the lower section dealing with feeding, and then the 3 specific nuisances. That's it.
But it's hard to define. It's hard to ask questions about something that's not even defined.
Not if you think about it and word it in a way that they can't wiggle out of saying no, if no's the answer you need.
Well, it's subject to interpretation for anybody to create.
No, it's not, Jane. It cannot be subjective because it must have actually happened. It cannot be something they think could have happened or might have happened or was possible. It must have happened. You get it? The feeding must have resulted in one of those 3 things happening. If they didn't happen, it's irrelevant.
So how would you say what, as far as danger to public health, danger to public safety, how would you say...
Didn't we just cover those?
Are if you don't know what they are, if they're not defined?
Again, Jane, we can make it where the prosecutor, the city attorney is the one that has to try to define it, and we get to object to it. Objection. There's nothing in the ordinance that defines that term that way. Is there? So it doesn't matter what the fuck they try to say it means. There's nothing backing it up.
I'm not saying what they said means. I'm saying the questions that I have to ask to get them to admit that there's no danger to public health and safety.
If they didn't put it in their report, then you don't really...
I mean, that's one of the elements. That's one
Again, Jane, it's not your responsibility to define the term. It's simply to argue that they can't prove how they're defining the term.
Matter of fact,
that
is the one thing that they're... Yeah, that's the one thing that they are trying to say that, that's the whole thing. Even in the evidence, the video evidence, or when I went and saw the body cam, and the prosecutor told me that they're not trying to say that there was more than 11 animals. They're not trying to say that I created...
Well, they alleged it in the complaint, so they damn sure are. If it's in the fucking complaint, that's exactly what they're trying to allege.
That's not what this is about. This is about the attracting of wild animals, dangerous or wild animals.
Again, they don't get to define what that is unless the ordinance says what it is. If the ordinance specifically says it's something that's not in the video, then and that no one can identify having ever seen, then what do they have?
They have nothing.
Exactly.
Jane, you're killing.
Okay. And you can get any one of the animal control officers up there who are the ones who are supposed to know what a dangerous animal is, right? So get any one of them on the stand. Can you please provide the evidence you have in your possession to this court that shows a dangerous animal lording on my property? And don't forget, that animal must be either presenting a danger to public health or safety, not simply be a wild animal. That animal must be destroying public or private property that isn't mine, or that animal there must be 11 or more of them, and they must all be adults. So, exactly what wild animal do you have evidence of on my property that I attracted through feeding that is in one of these 3 categories?
Well, I thought you said I couldn't say dangerous animal.
Again, You are the one that just made the argument. They're saying that it's to prevent the attraction of dangerous animals.
Well, she's saying wild animals. She's saying wild animals.
But again, that's not in the ordinance, is it?
No, it's not.
Okay, so in the ordinance, objection, Judge. The state is trying to prove an element that doesn't exist in the ordinance. There's nothing in the ordinance talking about wild animals. There's nothing in the ordinance talking about dangerous animals. The ordinance talks specifically about an owner feeding an animal in a way that creates one of these three nuisances, none of which, by the way, were ever created. And the prosecutor or the city attorney is well aware they were never created. And yet here we are. That's how you would object to her trying to use the conflation of dangerous animals with the requirements of the ordinance. So don't let her. Okay, so do you understand the point I'm trying to make here?
So can I ask, Smith, is no wild animal enter your garage or try to enter your home as a result of the actual...
No. There's nothing in the ordinance talking about an animal entering somebody else's property, is there?
No, I'm just saying as a result...
You don't have any control over wild animals, Jane. So why the fuck would you ask somebody, a third party, a question about some wild animal entering their garage?
So then, has she ever felt threatened by any animal that she believes?
No. Any animal. There you go, leaving an open-ended sledgehammer to be hit, for yourself to be hit with.
Okay.
Never use the word any.
Okay, so...
Unless it is, you never actually witnessed any danger to public health or safety, right? You never witnessed any public or private property being destroyed, did you? Okay. You never witnessed any 11 animals of any kind, adult or otherwise, congregated on my property. That's the only way you use the word any.
Okay. All right. Okay.
Anything else is a wild, open-ended question that's going to get your ass in hot water and give the city attorney an open to come after you. Don't do it. You may as well be a boxer facing Tyson and do this.
Just attack the elements.
I'm sorry, my video's off. You may as well be a boxer facing Titan. What the hell are you doing? Turn on. Thank you. And doing this. Okay? It'd be a stupid move. Don't do it.
Well, you can say questions related to any as far as you do not collect any evidence that the alleged feeding of animals by their attack the wild animals.
Again, you have no evidence that proves A, B, or C, right? You have no evidence proving A. You have no evidence proving B. You have no evidence proving C, right?
Okay.
If I go up here and just do a control F, let's see. I am gonna put the word inclement. I don't know if you can see this or not, guys, but I put the word inclement in here and it comes up 0/0. Nowhere in here does it
0/0, meaning didn't find any of any, because it just fucking ain't there. And that's exactly what would happen if you put dangerous animal into the ordinance and searched it. Okay? That's what would happen if you put wild animal in the text of the ordinance and searched it. It just ain't there. So don't talk about it. Stick to the words in the ordinance. Strictly.
Yeah. In that particular, yeah, you're right. But it is in the ordinance, dangerous animal, but not in the code that you're searching in.
Correct. Therefore, nothing else around it is relevant, right?
Okay.
talk about inclement weather. So when Officer Tatum says, hey, it's inclement weather, and you have to know as a law student that he's introducing new words that are not in the statute. The only thing we lawyers are concerned about is during any rain, smoke, or fog. That's it. I don't want to hear about inclement weather. I don't want to hear about low visibility. I don't want to hear about wet roads. The Florida legislature said during any rain, smoke, or fog. So pay attention to that. Did you get it? Did you get the inclement weather injection? If you got that, then you got an A on that pop quiz, and I really am impressed. If you got the B, then that's fine, but if you got an A, give yourself a pat on the back. Hold up, let's pause for a second for a quick word from our sponsor, Chapter Medicare. If you or someone you love is dollars on Medicare, this matters. The highest kickbacks and not the plan, Medicare plan, to find the one truly tailored to save you hundreds. The number's right here in 6-3. Give yourself peace of mind today. All right, let's keep going.
If somehow it wasn't inclement weather, which means it wasn't raining at all, you wouldn't still see rain droplets on his car. Inclement weather doesn't mean that it's only inclement at the instant that it's raining.
Actually, in this case, that's exactly what the fuck it means.
Yeah.
Therefore, Tatum is wrong.
And splash.
As is the cop who pulled him over in the video. Now, unfortunately for the kid, his defense attorney didn't do any better job than Tatum does. His defense attorney didn't argue that the stop was invalid or anything else, and he should have. But he didn't, because he didn't bother to go read the statute either. So the kid pled guilty to the traffic infraction and something else, but I forget what it was. But he shouldn't have pled guilty to anything, because the stop on its face was illegal. Which means everything they discovered after the fact was fruit of the poisonous tree.
And then if it stopped raining for 30 minutes or 30 seconds, then all of a sudden it's not inclement anymore.
Do you see a problem with Officer Tatum's thinking about this statute? He says that if the rain stops 30 seconds or 30 minutes from when the officer pulls over the driver, then that doesn't mean that it's not inclement anymore.
Notice that the word inclement is the same word that the cop who pulled his kid over used when he first walked up to the window when he said, "You're not using your headlights in inclement weather." The cop that stopped him said exactly the same thing.
Tatum didn't read the ordinance or the statute?
Obviously not. And neither did the cop that initiated the stop. Or if he did, he didn't care, or he didn't understand it. All of which are plausible and common. But the point being, they all made exactly the same mistake as cops.
You, my little law student, do you see problems with this legal analysis? Hopefully you're all A students now and you're asking, where in the heck did inclement even come from? It's not in the state statute. It's not in the law. And we already discussed what happens if the rain stops 30 seconds before the driver is pulled over, or certainly 30 minutes before the driver is pulled over. That's crazy. If the rain stops 30 minutes before the officer pulls over the driver, then the officer did not pull over the driver during the rain. It's not during the rain if the rain stopped half an hour ago. I love that you guys are going to be able to analyze these facts legally, just like an attorney would. Let's go.
It's not just the rain. It's rain and rainy conditions.
Oh, are you catching it? Are you catching it? He said it's not just the rain, it's rain or rainy conditions. Law student of mine, was that in the statute? Here again is the statute, and it says every vehicle operated in Florida on a highway must have its headlights on during any rain.
Notice that the only place the word conditions is at the end of one, under the following conditions. And the conditions it lists are what? During any rain, smoke, or fog. So it doesn't say rainy conditions, like Tatum is saying. It doesn't say inclement weather, or potentially inclement weather, or recently ceased inclement weather.
Smoke or fog. Do you see anything about raining conditions? Which is what Officer Tatum just said. Do you see anything about inclement weather? Do you see any grace period of 30 seconds or 30 minutes? You do not. You just see during any rain, smoke, or fog. All right, let's get back to our brother Officer Tatum. And hopefully you guys are analyzing this correctly. Hopefully you're getting A's on these quizzes.
The hazardous lights and putting your lights on is for the conditions that's associated with rain. When it rains, visibility is lower. There's rain on the streets. People need to have better visibility when driving. That's what the spirit of the law says. That's
that's what the spirit of the law says. I will tell you. And again, none of this is taking shots at Officer Tatum. Excellent content creator. I'm sure he was an excellent officer. I am just looking at this from the lawyer's point of view.
He was not an excellent officer, as this is how he analyzed all the laws he applied. Despite his belief he was an excellent officer, this is proof positive he wasn't as good as he thinks he is. And like I said, I like the guy. I like a lot of the content he puts out, and I watch it quite a bit. But I've also watched videos where he has made many, many mistakes. So this is exactly why I exist. Because even those who are supposed to know don't. And they don't care to be corrected even when they realize they're ignorant.
Bring him into the class.
I don't think it would help, but we'll see.
Because again, this is a legal case. We are talking about state statutes. I will tell you as a lawyer that when anybody says the spirit of the law, then you know you got them. When somebody has to retreat to the word spirit, it means that the arguments that they're making are not in the statutes textually. When you are in court, when you're in trial and you hear opposing counsel say, oh, well, that's the spirit of the law. That's what the legislature surely meant. I'm sure that if the legislature had more time, then they would have said, they would have clarified, they would have put in writing. Whenever you hear someone say it's the spirit of the law, you know you got them.
And Judge, I'm sure it's the spirit of the law, or that the spirit's intended the prosecutor get charged with idiocy. Because that's exactly what they've presented to this court today. A case that didn't exist for an offense that didn't exist to maliciously prosecute one of the people that live here out of strictly vindictive reasons. See, you can use that spirit of the law thing a lot of different ways.
This lights and putting your lights on is for the conditions that's associated with rain. When it rains,
again, nothing in the statute says conditions associated with rain. He's got this wrong at least 7 different ways that I've counted so far. He substituted words that aren't in there. He's created conditions that aren't in there. He's created circumstances that aren't in there. He's created visibility issues that aren't in there. He's created all kinds of things that have absolutely no relationship with the wording of the statute in any way, shape, or form, including the spirit of the statute, since the spirit is confined to the words used to make it.
That officer in that video, the audio I sent you also, he tried to define what the statute was that he was charging me under.
What do you mean he tried to define it?
He tried to tell me what the statute was. And you can hear him say what it was, but I don't, off the top of my head, I don't remember exactly what he said it was, but he did try to tell me what the statute was that he was charging me under for speeding.
Okay. I'm pretty sure it was 545.351 or 352.
No, he didn't say that. Because I kept asking him, you know, if I'm not anyway, you just have to listen to it.
Eddie, when there's confusion about a statute, now Officer Tatum obviously just pulling shit out of his butt, but when courts are misconstruing a statute because the statute is kind of shit itself, how do you get an actual legislative intent document, something to that nature?
You don't. The courts are not bound by legislative intent. They're bound by the words of the statute. The intent is defined by the actual words used to write it. The Supreme Court in every state has ruled that way, and the United States has ruled that way. Okay? Legislative, you can only guess at legislative intent. Therefore, you must go by the actual words used to convey that intent. And the statute says what it says. That's the intent. For all intents and purposes, no pun intended, that's what it is.
Okay. I actually went as far last year to actually watch committee meetings to find out why they changed a certain section of a statute. And crazy enough, the court misinterpreted what was on the damn statute that got changed and used it against me. That's one issue. 2, they used a statute that was changed that wasn't in effect when I filed my suit. So they misquoted the law twice. That's why I'm asking that question, is how do I get something since the meetings...
Well, that is appealable error. That's judicial error.
You're right.
That's an appealable issue. You go on appeal with it. You document it and you go on appeal.
And guess what the 10th Circuit did? They ignored it.
How did they ignore it?
Well, the crazy thing is I discovered it in the midst of the appeal because, you know, I'm not a lawyer. I'm not the smartest guy in the world, but I something in my gut says, wait a second, I don't remember that language. I've read that statute many times. And I decided to go back a year, you know, this is a year later, and look at it, and holy shit, I discovered that him or his staff quoted the updated version that had language that was not there before, and he used that language against me. So I brought it to the attention.
But it was not in effect at the time that whatever it was they were suing or prosecuting you for occurred.
Correct. And so I made a supplemental brief, and I brought it before their attention, and defense freaked out because they missed it too. They jumped right on it the day after I submitted it and said, well, it doesn't change anything, blah, blah, blah. Well, it certainly changed things. But the court absolutely ignored it. They didn't mention it. They didn't mention the original version, the new version of any, and in the discrepancy,
and
they just
that's why you appeal above them. Never
I
stop at the circuit courts, because the circuit courts get this shit wrong all the time. They don't care if they get it right, because they know it's going to wind up in front of a Supreme Court, or the Supreme Court's going to ignore it and nobody will ever address their fuck up. That's the biggest problem that we have with getting justice in this country, is that the Supreme Court is not required to hear any appeals that go to them. They can cherry pick whatever the fucking case is they want.
Look in the criminal rules too.
Okay? And therein lies the problem with the circuit courts. They know they're not going to get overturned because the odds of you getting the Supreme Court to see your case is so freaking small, you might as well be playing the lottery with it.
And that goes to the Court of Criminal Appeals of Texas too.
Okay, and that's the issue. So what you've got to do when you go above the circuit courts is you have to make your argument in a way that the Supreme Court can look at it and go, you know what? We've got X number of circuits that are doing it this way and X numbers that's doing it that way, and none of them are doing it right. Therefore, we need to address it and fix it. That's how you get the Supreme Court to hear a case. It has to be an issue they haven't previously ruled on, and it has to be brought to them in a way that gives them a reason to have to solve it by addressing it. Now, your other option is find the Supreme Court case that says what the 10th Circuit did was wrong, and then appeal to the Supreme Court to have them force the lower court to uphold the ruling they made. The Supreme Court made, that is. Stop.
Well, there's a number of issues that I won't get in. Obviously, I can't bring them all up here, but I'll take that advice. I'll try to find something to that nature. I'm just structuring it. When a lower court makes an error, that's a big deal. I've actually talked to attorneys about this. They thought for sure this would get flipped over. And the fact that they didn't even mention it means they're not taking the case. They don't want to deal with the case. So there's got to be something out there that says if a court makes an error that's detrimental to the litigant or the petitioner, it falls in their favor. There has to be something out there for that.
Well, it is. It's an interlocutory appeal or a mandamus, depending upon which action they did or didn't take and what they were required to do. That's what those two are for. Interlocutory appeal. Hey, the court's either defining this wrong or doing it wrong, and I need you, the higher court, to tell them to fix it before this is over. And to get it right. The other option is a writ of mandamus to force them to do something they're required to do and didn't do.
Well,
you ever heard? Okay, so I've got to find cases that state if they've failed to apply the law properly or address the error, then that's obviously a big deal. But
no, there's plenty of cases like that. That's where the issue of appealable error comes from. Is cases exactly like that.
Okay.
What you need is cases that support the action you intend to take, and there's three possible actions: appeal it as judicial error, or make an interlocutory appeal before it leaves the side you're on, or a writ of mandamus before it leaves the side you're on, the court you're in, I should say. Okay. So if they've already ruled on your case, then all you've got left is the appeal. But if it's still ongoing and they haven't finalized the case, then you can do one of the other two.
They ignored it, though. So.
Yeah, they've already finalized it. That's why I'm into the en banc.
Okay, petition. Then what you do an en banc petition, but you still show the Supreme Court case that said, here's why I requested en banc. You guys didn't do it right.
Right.
So you're still in the same court, and no, they didn't finalize it if you've gone back for a hearing en banc. If you've gone back for a hearing en banc, that one will be final, and then you'll have to go to appeal.
So you don't do the en banc in the higher court that's above them?
The only court above them is going to be the U.S. Supreme Court, which is always all of them. Well, that's not always true either. Sometimes they'll do 3 judges that send it back down to the lower court and say, fix this problem. And that may be very well what they do in your case. But to hear the entire Supreme Court hear it in order to make an actual opinion on it, if they've already made one, that's a lotto number. A winning lotto number.
The reason I asked that question about legislative intent is because there is a statute in Wyoming that the federal courts are twisting into a pretzel. They have no idea what they're talking about. And just recently in Wyoming, the Wyoming Supreme Court clarified some provisions that are available that are not specifically stated in the statute. And so the Supreme Court made a ruling and added essentially to the statute in their case law, and the federal courts are absolutely 180 degrees misquoting it. So that's why I asked about
misquoting the Supreme Court opinion or the statute.
They either don't know about, both. They either don't know about the Supreme Court opinion, even though defense and myself pointed it out. Defense tried to bring it against me, but in that case, it actually helped me. And I pointed it out, and they ignored it. So that's what I mean. And they made up their own version of this. Then they went back and made up their own version of the statute, basically ignoring that Supreme Court ruling.
Well, so you're talking about a state Supreme Court ruling, not a U.S. Supreme Court ruling.
Well, no, but I'm in federal court, so
I understand you're in federal court, but you're saying they didn't properly analyze a state Supreme Court ruling, not a U.S. Supreme Court ruling.
Correct. That's one issue, yes.
Okay.
Yep.
Well, again, normally the federal courts take whatever the Supreme Courts of the states or the courts of the state in question, they take it the way they take it. So if they're misinterpreting or misreading the Supreme Court opinion, then you need to raise that issue. But that still becomes a judicial error issue.
Right.
Okay? So you use that judicial error to go en banc before them and have the whole court review it so they can tell the ones that messed up, what the fuck are you guys doing? That's not what it says. That was never what it said.
Correct.
So that's what you do with your brief. Is you say, here is why the panel got it wrong and why I requested an en banc proceeding. Or an en banc hearing or an en banc review or whatever it is they want you to call it.
Right. So here's another thing I'm sure you've seen.
Go ahead. Sorry.
This is kind of for everybody so that we all are learning what we're up against. But have you seen the term that the court cannot be an advocate for pro se? I'm sure you've heard that term, right?
Say again?
Yeah.
The court cannot be an advocate, a quote unquote advocate for pro se. Now,
yeah, well, they can't be an advocate for anybody else either.
Exactly. But I've dug into what that means, and I understand it very clearly. It specifically says if your pleadings are deficient or if they can't basically have all the elements stack up, they don't have jurisdiction. They don't have a claim before the court. Now, that's what it's used for. It's generally buried within the document or within the ruling that, okay, the pro se litigant or whoever it was pled insufficiently, and then they quote that, and that's usually somewhere deeper in the ruling. In my ruling, they started off with the first phrase, 2 phrases. We take pro se litigants to be less, we hold them to a less stringent standard, and 2, we cannot be an advocate for a pro se. I have never seen a case out of probably the hundreds now that I've read, skimmed through. I have never seen a case that started off with that statement, which means they're signaling we're not taking this case seriously because we're not reading it.
Because you're not a lawyer.
Exactly. And that's number 3. That's one of the third mistakes they've made. That's pretty alarming. So I'm trying to stir up some politics on that because that's super inappropriate to basically signal we're not taking this case seriously. But they've also misquoted law. They've done it 3 times on that statute. Because there's 3 case laws out there that support, a different interpretation of the statute, and 2 of them come from Wyoming, by the way. from the Supreme Court. So I'm trying to figure out how to start off this en banc and get everybody's attention, but you know, that's also a gamble. It's a lottery gamble as well.
Yeah, hang on 1 second, guys. All right, so continue. I'm sorry, I didn't mean to interrupt you.
No, I'm just, it's a, you know, obviously I've been given a challenge. Like, how do you get the court's attention when they're just dismissing you and making it look like they're ruling? And I'm trying to stir the pot. And I'm at a level where we're one below the Supreme Court of the United States, and I have, you know, this is my first gig like this. I'm super green, but I know enough to read between the lines. So when I file that en banc, I want to get their attention. I know there's at least a couple of judges have to be in that circuit, and and they're the ones who are going to vote. So it has to get before their eyes, and that's the thing. There's enough errors here that there should be some concern, but how do I make it a concern? You know, so that's basically what I'm asking about.
Well, you simply write in your pleading that I believe the 3-judge panel erred in the following ways, and then you state the specific legal points that you cited that they either ignored or misconstrued, misinterpreted, misapplied, whatever they did wrong with it, state it. Okay? And then state why you not only how they got it wrong, but why you believe it was wrong and what you believe the correct interpretation should be. And that you request the court to make the determination on which interpretation is correct. That's their fucking job. This is what he thinks the law says, and here's what I think it says, Judge, and I need you to tell me which one of us is right. That's all this shit ever is. We can't both be right and this be a case. If we're both right, why the hell are we here? If neither of us are right, why the hell are we here?
Right.
So one of us has to be right, and the other one has to be wrong. Or there's no controversy.
Right. And it's the first time I've also ever seen a case ruling where they, you know, I generally have a 60 to 70% beneficial opinion about our courts, because when they're kicking your butt out of the court, they're telling you why.
Usually.
Generally. You didn't do this, you missed this, and here's the law, and here's the ruling, and here's the case law. And I've seen that multiple times for pro se,
as have I.
Obviously for pro se litigants. Okay, but in my case, they basically had a simple statement without any backup. It was an opinion of theirs. It was a biased, emotional opinion. We can find no reason to support the argument, and that was it. They didn't back it up with this. This is why you're wrong. This is what the case. This is why you missed out.
Right,
and
then believe it or not,
like,
I believe there's a Supreme Court ruling that says they have a duty to notify you of exactly those things. They can't just dismiss the issue out of hand. They have to try to show, okay, this is what you're missing. They have to give you a reasonable amount of information to correct the problem. When they don't do that, that's grounds for alleging they're acting biased.
Okay. I think that's even in the judicial conduct codes of
yes,
states.
It is. But that judicial conduct code is the result of much case law. The rules of professional ethics and judicial conduct all started with cases. A judge can or cannot do this. Here's the ruling. Now make a rule that shows they can't do it that way. Okay. Almost all of them started that way.
Okay.
All right. Y'all ready to continue the video?
Yep.
Yeah, thank you.
Yep.
Visibility is lower. There's rain on the streets. People need to have better visibility when driving. That's what the spirit of the law says. That's
the spirit of the law. Let's go.
That's why no one contested that he was pulled over rightfully. You would not.
See, there. Tatum just said what I said. Even his defense attorney did not contest whether or not the stop was lawful. Which shows his defense attorney also did not read the fucking statute. And that, ladies and gentlemen, is the best way in the world to lose your case and get found guilty. Or have to cop a plea because you don't have any other defense.
Not have rain droplets on your car if it had not been raining. The ground is wet. It is raining, ladies and gentlemen.
Again, if it had not been raining, not because it is currently raining. You catch that? Back it up just a little.
If it had not been raining, the ground is wet. It is raining, ladies and gentlemen.
Not been raining. Now it is raining. When we can clearly see right here in this frame on this car, there is no new water forming on that car. It is not raining. So again, Tatum is cop-splaining. He's not legally analyzing. Big problem.
Maybe it stopped raining for a small period of time.
Oh, that sounds like an admission to me. It sounds like Officer Tatum really knows what's going on. Sometimes as attorneys, guys, we never know if people are pulling our legs or not. As lawyers, we don't assume that you know the law. So it could be that Officer Tatum just doesn't know. But when he says, oh, well, it could be the rain stopped for a moment in time, that kind of gives me the impression that he knows what the statute says. If the rain stopped for a brief period of time, then what does that mean?
And that's exactly the problem with a cop. If he does know what the law says and he misapplies it and misuses it anyway, that's not a good cop. That's a dishonest cop. That's a cop with an agenda. And we don't need any more of those.
Means that the traffic stop did not start during the rain. The focal point of this whole issue is the word during. What did our man say again?
It is raining, ladies and gentlemen. Maybe it stopped raining for a small period of time. That does not preclude the justification of having your lights on during inclement weather.
All right, guys, as your law professor, not going to beat a dead horse, but I'm going to replay that last sentence one more time, and I want you to analyze it.
It is raining, ladies and gentlemen. Maybe it stopped raining for a small period of time. That does not preclude the justification of having your lights on during inclement weather.
Inclement weather. All right. If you're my law student, hopefully you see the issue with that. Shout out to Officer Tatum. Shout out to Lackluster. They're both going at it. If you guys like this video, just let me know and I will break down each of the issues so that you can understand how to analyze these things. You don't have to believe Officer Tatum. You don't have to believe Lackluster. You can think of it for yourself and then you won't be leaving me comments like this. These are laymen here, great people, great subscribers of mine commenting. Do you see any problems with what they're saying? It was raining. What is was? Does was mean during? The car is wet. All right, do you see a problem with that? It's raining. Look at the car glass. Lead. Is his car wet? Water on the vehicle. Was it or is raining? It's rain on the window. If it's raining, should have the lights on. Now this is true. If it's raining, shout out to HKW. If it's raining, the light should be on. The ground is wet, water particles on his vehicles. Yeah. All right, guys, we'll end it there. Just let me know in the comments if you want me to break down each one of these factors for you so we can get down to the real nitty gritty and know who is right legally. Just let me know in the comments below.
You don't have to answer that question.
All right, so given that, let's go over a couple things real quick. Now, this is Rebecca's questions for Jane's cross-examination. Okay?
What witness? Any?
Well, it's for an animal control officer. Doesn't have to be anybody specific. Challenge danger to public health or safety. Can you specifically name a member of the public who suffered any actual harm or health impact as a result of my alleged actions? What is the issue or non-issue with that question?
Well, I don't want to say my, for one.
Why? It's your actions that they're trying to prosecute you for.
Just like I don't want to say my property, you know.
Again, the issue is your property.
Yeah, in case, yes, I do. It is private property, so it is my property. But I would say respondent's action.
What is the problem with this question?
Okay, well, I was thinking that had to be because it's that can name anybody in the public who suffered actual harm.
What kind of question is this not?
It's open-ended.
That's right. It's an open-ended question. Do you ask open-ended questions on cross-examination?
No.
No. Never. Never, ever, ever.
I didn't catch that right away. Yeah.
Okay. Now, you could have asked something. Were you specifically harmed in any way that you have evidence of?
As a result of
Because we can't ask if anyone else got harmed. That person isn't here to testify. That would be a hearsay answer, wouldn't it?
Yeah.
We can only ask about what the witness on the stand has personal knowledge of. And we need to ask them in the form of a leading question so we get to put the words in their mouth that gives us the answer we need. Period. If you're doing it any other way, you're playing roulette. Russian roulette. You got me? All right. Can you name a member of the public who suffered any actual harm? Same problem. So to be clear, the city's case is based on a hypothetical danger that never actually occurred. That's a leading question. The problem is, it's a question the witness can't answer.
Yeah.
How is the witness supposed to know what the city's case is based on?
Yeah.
That's the prosecutor's job, not the witness's job, right? So the witnesses, there's going to be an immediate objection. Objection, calls for speculation. Objection. There's no way the witness can read the city's mind. I'm the city's mind, and I didn't tell them. You get it?
Yeah.
ACO. Well, we do have video of her feeding animals. If that's an answer they get, great. Thank you. Just so we're clear, you're not disputing that no member of the public was actually harmed. Again, didn't want to ask that question to begin with. You're now relying on video of me feeding animals to justify your claim that I created a danger, correct?
Open-ended.
Now, if you leave the word now out of it, you can ask this question. The way I would ask it is, you're relying on a video that shows me sitting something on the ground outside my house to justify your claim that I created a danger to the public health and welfare, correct? That's the way I would ask this question. And the answer I would get out of this is probably a yes, okay? And then we can say, and is that video one that you personally made yourself? No. Then what video are you talking about? The one she's got. Oh, objection then, Judge. I move to strike all this testimony then because that video has not been introduced into evidence. And therefore, this witness is testifying to hearsay at this point.
And that's exactly the way it's going to be.
Okay. Now, if they introduce it later, great. Recall the witness and ask them these questions again. Now that we've seen the video, is that video what you're relying on to claim that my feeding animals justifies that I actually created a danger to the public health and safety, or that actual damage to public or private property other than my own occurred, or that there were 11 or more adult animals congregated around whatever was in my hands when I set it on the ground? Is that the video you're relying on to make those allegations? Because I didn't see any of it in the video. Can you please tell us exactly where in the video you see those things? And none of it's there, is it, Jane?
No.
So that's how you would use it, and that's how you would ask it. That's how you would kill all three of those nuisance elements in one shot. This is why I keep telling you, don't make the mistake of introducing language that isn't there. Okay? For instance, does the video show any member of the public suffering harm? Again, why is this question necessary?
He's thinking like
there's nothing in the statute that says they have to show a member of the public suffering harm. It shows that a danger to the public health or safety actually occurred. That's all it says.
Well, so then why would
So the issue is, what danger? What danger are you specifically saying occurred as a result of me putting on the ground whatever you think I put on the ground?
That's what you're doing.
Okay? Not could it happen, not might it happen. Did it fucking happen? There's nothing in the video that shows a danger of any kind that I can identify. What danger are you saying the video proves? What danger are you saying is written into this idiot's affidavit? Because I don't see danger in here anywhere. I see a bitch and moan session written on paper. That's what I see. And this is what you based the citation on. A statement that doesn't allege anything and a video that doesn't prove anything. That's your case. Well, good fucking luck.
Eddie, when we're challenging accusations like this, should we ever go outside of what they actually are?
When they're this cut and dry, no.
Okay. If there's like 2 or 3 things that they've accused Jane of, should she argue anything other than those 2 or 3 things?
No. Why? All you have to do is break the leg on those 3 things. Because those three things, if they don't exist, there is no offense. The offense can exist if any one of the three are true, which is why we have to kill them all, because they alleged all three of them in the complaint.
Is there a probable cause affidavit that is in with this?
No.
Oh.
The complaint is the only thing there is. There's been no probable cause determination, which is a whole other due process problem with this case.
Gotcha.
Okay? But the fact of the matter is, there is no case because there is no evidence of any kind of any of those three things ever actually happening.
Okay.
There's no evidence of the predicate to those three things actually happening. There's no evidence going to be introduced in the court that Jane owns the animals, which is the predicate. It's the very top level predicate, because it starts off saying the owner of any animal. So you must be the owner. And they're not introducing any evidence that Jane's the owner of anything. Okay? The second predicate is the owner must have fed the animal in a manner that creates one of these three issues. Well, there's no evidence that the feeding in and of itself is an offense, and there's no evidence that the feeding resulted in any of these three issues. So if we kill these three issues, nothing else matters.
Right.
So why would you ask a question about anything that doesn't prove those three things never fucking happened? And that they don't have any evidence of the two predicates required to even get to those three things. Why would you ask questions that deal with anything else?
Yeah. Well, the questions that I have on here, I was only going off of what I could pull up that was from the file that you had shared, because I wasn't able to open all of the files that were in her specific folder.
Well, it should have just been Word docs and PDFs.
Yeah, some of the PDFs I weren't able to open. I don't know if it was just something wrong with my computer or something.
What are you using to open them?
Just a PDF reader.
Is it Adobe PDF reader or is it something else? Is it a third-party reader? Okay, there are some third-party readers that can't read certain newer versions of the PDF. If they were produced with a newer version of the PDF format, the older programs can't read them.
So if I downloaded Adobe or something on here, I'd be able to read
Yeah, you can. The Adobe Acrobat Reader is completely free.
Right.
And it'll work with damn near anything except for a third-party PDF creator that just doesn't know how to create a PDF.
Gotcha. I'll download that.
Okay.
I've got a quick question. Can you hear me?
Yeah, I can hear you. Go ahead.
Well, as in a criminal case, would Jane be able? Can the prosecutor call Jane to the stand to testify, or
no?
Or is it
not unless Jane gets on the stand of her own volition.
Okay. And just one more quick question. Can Jane call the prosecutor, and would there be any...
No, the prosecutor is not a witness, nor can the prosecutor be called as a witness. The only way that the prosecutor could ever be called is if you can show that the prosecutor is the sole witness to a specific aspect and fact pattern relating to this case that would prove or disprove one of the elements of the offense or the entire charge.
Right on. That makes total sense. Thank you.
Like, for instance, you have evidence that the prosecutor is actually the one that committed the crime you're being prosecuted for.
Right on, yeah.
Okay. Now, for instance, this question here, does the video show any member of the public suffering harm? Well, one, we don't care. Okay? Because that's a question, the witness, how do they know what constitutes a member of the public? How do they know what constitutes a harm or suffering? This would all be speculation as to whether or not anyone that they could see in the video was suffering harm. Hell, they could be having an asthma attack that has nothing to do with the animals.
Right.
So, how does traffic accidents figure into the elements of the charge? They don't. Nothing about feeding animals has anything to do with a traffic accident.
Well, running over to my place to eat could be causing.
Unless the car actually entered your yard. Okay? Injuries, again, What if someone was falling off the roof in the video? Yeah, there's injuries, but how do you relate it to the feeding of 2 cats?
Well, cat bites.
If the cat was jumping on them and knocked them off the roof, that'd be a different issue. But that's a domestic issue. That's not a public health and safety issue.
Right.
Okay, again, how is the witness on the stand supposed to identify a disease outbreak? That's the CDC's job. That's whose job? That's your local CDC's job. How would the witness on the stand know that?
But property damage.
And the only property damage the witness can testify to is property damage they witnessed. But does that make them an expert on what's private or public property? So again, the only property damage the witness can testify to is their own property. Okay? That's it. Or property in an obviously public place like a park, which we're not on. All the animals in question are on Jane's property except for the one on the hood of a car, which no one's testified as to who owns the car.
No, it's not on the car. My brother. It's in my firebox now.
It's what?
Without Jane's testimony, then there's no way for them to prove.
Even with Jane's testimony, Jane's not going to testify that any of the 3 things that constitute a nuisance occurred.
No, I'm saying without her testimony, they have no way of proving ownership of the animals, correct?
Correct. Not unless they got actual paperwork.
Yeah. So they have one of the primary elements of it they have no proof of, as well as
one of the primary predicates.
Predicates, okay.
Okay. You got to remember, there's the actual elements of the offense, and then there's the predicates that you have to get through in order to get to those elements. So basically, there are 2 doors between the actual offenses and ever blaming Jane for committing one of those offenses. You have to get through the ownership door, and then you have to get through the actual feeding being the cause of the nuisance.
Right.
Before you get to the actual nuisances.
Which of those 2 would she attack first?
Well, again, she can work in any direction she wants to. Okay? And I would start at the top and go down. What evidence, and I did that a while ago when we started class, I was going like, what evidence, what documentary evidence and everything do you have to present to this court today showing that the animals in the video, assuming the video's even been shown yet, that the animals that are alleged in the complaint I own? What is your evidence I'm the owner?
But since they didn't put that into the complaint as far as as far as what it says.
No, Jane, we want to ask it because it's a predicate of the offense. Okay. The fact that the complaint doesn't have it is exactly what we're going after.
Okay.
The state failed to allege the offense.
Not the state, the city attorney.
Well, the city attorney. Okay, the city attorney failed to allege a primary element, a predicate element, that I am the owner. That's nowhere in the complaint. And they have no evidence to present to the court that I'm the owner of any of these animals. Okay? Second thing is, part of the complaint alleges I fed the animals in a manner that did these things. Well, there's nothing that defines what manner constitutes an offense. There's nothing in the ordinance that says feeding in and of itself, indoors or out, is an offense. So just the feeding alone doesn't constitute an act to be prosecuted for. And the state's got no evidence that the feeding alone caused anything. Now, if we get down to the individual nuisances and we go through each of those like I've done multiple times already, the state can't prove any of them because there's no evidence proving that there was any danger to the public health or safety. Absolutely no evidence of any kind.
There's no offense at all of any kind. So
exactly. So thus far, the city attorney is attempting to prosecute me maliciously, I might add, for an offense that doesn't fucking exist. And she has been told multiple times it doesn't exist. And that she has no evidence that any of it exists. And yet, she's here trying to prosecute me anyway.
And she's lying and misstating what it says in the Texas Constitution.
That you can't do, Jane. You cannot. That's you testifying. That's you making an allegation you can't present evidence of unless you get on the stand. So shut the fuck up, because you are not getting on the fucking stand.
It's in our motion, though.
Again, Jane, what's in the motion isn't necessarily going to be what you have to ask at trial or what you're even going to be allowed to talk about at trial.
Okay, can we go over some of those questions that I was going to ask? Or, I mean, my opening statement things?
Yeah. That was the next thing I was going to go over. Okay? But the thing about it is, your questions, no matter what you're thinking of, your cross-examined questions need to be specific types of what kinds of questions?
Leading questions.
Leading questions, and only leading questions. Okay?
Yes.
And they must be asked in a way that will get the answer you need and want.
Yeah.
Not one that boomerangs on you.
All right.
Okay? Keep it simple. Focus only on what the state must assert and prove. And then show they either didn't assert it or they failed to prove it. And that, by the way, Jane, is both your opening and your closing statement. Okay? You can sit right up there and you can say something like, the facts of the case are these. I have allegedly fed animals in the front of my house. The state is alleging that that feeding is illegal in and of itself, and the ordinance says no such thing. The state is also arguing that I caused a danger to public health or safety, but the state has no evidence of that. They only have basically a subjective opinion about what could happen, not what did happen. And you just march right down through them saying, this is the story, and this is what they're going to try to prove, and this is what they have to prove, and they don't have any evidence to back any of it up, and that's what the facts are going to show. And then at the end, it's the exact same thing, but with a different tone. The state did not offer any evidence of this. The state did not offer any evidence of this. No testimony proved that this happened. None of the witnesses ever saw this. None of the witnesses ever produced any video or any complaint saying that any of this ever happened. There was never an offense. Period.
So can I ask any?
And the moment that this, and you may never get to your closing statement. Now let me tell you why. Okay? The moment the city attorney says the prosecution rests, or the city rests, or whoever fucking rests, their case is done.
Yeah.
In that moment, you will stand up, look directly at the judge. Judge, I move for a directed verdict in the favor of the defense. The state has failed to prove a single offense in this case. Not one. They have introduced zero evidence that any violation of this ordinance ever occurred. Zero. That's it.
Well, I can't say any of these things in the opening statement.
What?
Well, not to say any of these things in the opening statement.
Pretty much. Do it the way, lay it out the way I showed you. You can do the introduction. Good morning, good afternoon, Judge, whatever it is. You can be cordial and you can be friendly, but you need to speak like you know what the fuck you're talking about, and you do it. If you do it with any emotion, Jane, make sure it's the right fucking emotion. And contempt, anger, resentment, I know what the fuck I'm doing and you don't, those are not the emotions you want to convey.
I understand.
You want to convey, I'm being mistreated here. I have been wrongfully accused of doing something that never happened. I am currently being prosecuted for something that never happened. Every piece of testimony and evidence presented to this court clearly shows none of this ever happened.
I hate to ask, but is it okay if you share that draft there of an opening statement that I can kind of look at to use to concoct my own?
Well, Jane, do you still have the link I emailed you?
Yeah, I think so. Yeah. I still like some of my opening statements, so I guess you know.
Well, again, what you like and what you should be applying, not the same thing.
I wanted to tell him what the case was really about, but anyway.
Well, you can say that I'm here simply because I have a vindictive neighbor that doesn't like me. You can say that in your opening statement.
No.
You can say it in your closing if you get to closing, but you should not ever get to closing. You should be at the perfect spot at the end of that, the prosecution rests, to jump up and say, I move for a directed verdict in favor of the defense. The state has offered no evidence to prove a single element of any of these charges. All right, look in the chat. There's the link to what I sent Jane about how to write a good opening statement in a criminal case.
Yeah, there's one criminal case in that list of examples. Well, I'll try to.
Hey, Eddie,
Thank you, Eddie.
Hey, Eddie, I've got a question about what was brought up earlier about the state government and the federal government prosecuting and being two different levels of government. There's no.
Okay, you're breaking up, so either get closer to your mic or don't move. You're breaking up, so either get closer to your mic or stop moving.
I'm on a ship at sea, so I apologize.
Yeah, okay. Well, that explains a lot then. Go ahead.
Yeah. My question was, since the state and the federal government are two different levels of government, there is no double jeopardy, as I understand it. If one can't prosecute you, the other can, correct?
Only if there's a violation of the federal law as well as the state law.
Right.
The state has no power to prosecute a federal offense, and the federal has no power to prosecute a state offense.
Right. But my question is, does the federal government, can they refer down to the state statutes?
I guess that depends on what you're talking about. If they have evidence that a state law was violated, yeah, they can share the evidence of that with the state, and the state can pick it up and attempt to prosecute the case.
Okay, so in the case that charges were brought against someone on a state level, and they were no billed, then the federal government could still pick up could still prosecute you as long as it violated the federal statutes, correct?
Yes.
Okay. But they can't refer down to any of the state stuff. It would have had to be in a direct violation of the federal law.
Right. The Fed cannot prosecute you for a violation of state law. They can only prosecute you for a violation of federal law. It's exactly the same thing when you try to claim constitutional violations. If you only claim it under the state constitution, the Fed courts can never hear it. But if you claim that you were harmed according to the federal constitution, the state courts can never hear it.
I see. Thank you.
This is exactly why if you file a complaint in a state court trying to sue a government official, and you mention the U.S. Constitution in any way as something you're making a rights claim under, boom, we move it to the Fed. And then the first thing that follows after that, 12B6 dismissal request. So if you're going to sue them in state court, you stick strictly to state law and state constitution and nothing about the federal rights. Now, you can literally sue them in both venues simultaneously if you want, but you have to be extremely careful to keep the complaint entirely devoid in each area of anything referencing the other area. You stick strictly to the federal constitutional rights in the federal courts and strictly to the state constitution and law rights in the state courts. Period. Now, if the state law violation of your rights occurred based upon a violation by the state of federal law as the basis for the state law, then guess where both of you can take it? To federal court. Because the base law is federal, and the state adopted it and implemented it, but it's still federal. Now, guess what that means in Texas? It means that you can move your traffic ticket to federal court if you know to show that the state law is based on federal law And it is.
Yep.
So now we go to federal court and argue the state is intentionally misinterpreting the federal law upon which the state law is based to use it in a way that oppresses the people of the state of Texas, violates our rights, defrauds us of our money, gets us killed, and gets us thrown in jail for crimes that we are not subject to ever committing.
But aren't all states subject to federal law because most of their laws are based off of the federal constitution?
Only if you can show the state law is based upon the federal law. If you can't show that, the state has power to make its own law. If you can't show a nexus between that law and the Fed, it stays in the state.
Gotcha.
The only way you can take it to the Fed is to show that the state law is actually violating your federally protected rights. Then you can take that to the Fed. Because then it doesn't matter what the state law is based on. And that's what I was telling y'all before. That's the reason why the federal constitution is the lowest point your rights can be held to, while the state constitution is the highest point. Now, what does that mean in reality? It means that the state constitution can offer you more protection in more areas than the Fed does. But those protections only work in the state. They don't work at the federal level because the federal level is the floor. You got me? So anything higher than the floor has to be in the state that gave that protection. You get it?
Eddie, before my neighbor has a chance to file some other kind of charges or miscellaneous bullshit, I found an application for a citizen complaint with an affidavit, and it has a sworn affidavit in there that you can fill out as far as ordinance violation and all that kind of stuff, and I can file directly with the prosecutor, and I can provide the ordinance violation and also tons of evidence. Should I do that? I want to do it now before she has a chance.
Is there a city ordinance against harassing your neighbors?
No, it's not that one. It's throwing her trash in my yard.
Well, that's littering. That's littering. What else is it?
I mean, it's actual. There's actual ordinance that says throwing trash on somebody's property doesn't belong to you.
Yeah, but there's also a state law. You know what that's called?
No, I know it's state law, but I'm talking about I could file it in this court.
Jane, listen to me.
What?
There is a state law that governs that type of event as well. Do you know what it's called?
Something about littering.
It's illegal dumping, Jane.
Okay.
And it's a lot more punitive. It's a much higher level offense than littering. If she's illegally dumping her trash on your property, that is a state law prosecutable offense. That can send her ass to jail.
It goes by poundage. They go by pounds because I already looked it up. I've already researched it. It's pounds, but and so she won't have a poundage.
I would be trying to nail her for filing a false report.
What about false report?
I said I would be trying to nail her for filing a false report.
Oh yeah, I've got multiple.
Well, the thing is, she's able to file a complaint, okay? And the issue here is that the affidavit she signed does not make an allegation of anything. Mm-hmm. It is simply what I said it was, a bitch session in writing. That's it. I don't like that she does A, B, C, and D. There's nothing in it that says she was breaking any law or doing anything that's against the law.
No, it just says James continues to feed the cats.
So is this lady in bed with the prosecutor then or something?
No, the prosecutor's a female, so is this old bitch.
No, the prosecutor's got history with Jane, and she knows Jane's been a pushover before, so she thinks she's going to make her a pushover again.
No.
Oh, so she thinks she can get one over on you to extort more money.
That's not the deal at all. On this case, you would not have seen that in motion, even, No.
I promise you, Jane, if you stick to what I'm trying to teach you to do with this, you will win this case. And you may not win it in this court, but you will damn sure win it on appeal. And when you do win it, you get to fucking sue everybody.
Yeah.
Every fucking body.
Well, I can sue one unit or the other. I can't, because it's they have laws against that too. You can't sue if you sue one particular unit. You can't.
Hey, hush up. What do you mean one unit? Define a unit, Jane.
Because I read it in Irving's, and not maybe it's not just Irving. I can't remember where all I read. But if you have, like, if say I sue the animal control officer, I can't also sue the animal control department. You can do one or the other.
No, you can sue them both because they are respondent superior. The animal control department is the one that's responsible for the misbehavior of its officer.
That
so
means
you have to allege failure to supervise and train, which means you sue the AOCs and you sue their supervisor and you sue their department. But you also get to sue the city attorney's office and the city attorney in this case, Cantu, and you get to sue the city for failure to manage and supervise the city attorney's office.
Not according to what I read in the their charter, I think it was.
I don't give a shit about their charter, Jane. Their charter does not supersede state law.
Oh, I think okay. I read it on the
No, their charter said they can be sued.
Yeah, it does say they can be sued, but it says one or the other. Like if you're going to sue the animal control officer, you sue that person, and you can't come back and sue the
right. You can't come back later and sue the city,
right.
But you can sue them all at the same fucking time.
So you're saying not to file this on my neighbor before she has a chance to file something else on me, because I've been getting a case after a case for the last 6 years, and I'm sick of it. There needs to be some way to stop this bitch.
Yeah, you sue them for everything they're doing wrong, and then you use this case to prove harassment. This is the same way they've handled every single case, knowing they had no case at all, with the exception of you stealing the cat trap.
Jane has a video where she is the aggressor, where it shows her actually assaulting Jane while Jane is working on her property.
Yeah, but the thing is, Jane never went after her for that.
Because I don't have a chance. I'm always defending myself. I can't, I mean.
But Jane,
okay,
you can
Jane,
still show a history.
I don't want to hear the I can't, I'm a victim bullshit. You had evidence that would have proven your side of things, and you should have filed a fucking complaint about it. Period.
But even still, after this, you can still take her down. Use that history, why you fear for your life and why you need that damn restraining order or something, or that lady needs to go get checked out by a truly qualified mental health provider, a psychologist, whatever.
It does, but I did go to the district court and try to file to get a restraining or protection order, and they would not do it because they said that she had to have threatened my life. And she didn't, so I can't prove that she threatened my life, and so they wouldn't.
Where is this video at? Is that?
Oh, I got tons
somewhere.
I got tons of videos, but even this morning on my live camera, of course, my digital camera or my wireless didn't catch it. He was out there saying, "Oh,
but Jane, she's threatening you with lawfare. She is threatening you with all these crazy waste of time and money in your life. There's a lot going on.
That's a vexatious litigant. If that's how you say that word.
Okay, well that works too. But again, the history, keep those videos, incorporate it wherever you can.
The vexatious litigant is how the courts stop you from filing cases.
That's what I want her to be able to have to do, because she's behind these two last
But the court can't stop you from filing a complaint. They can only keep you from filing civil suits with vexatious litigant.
Yeah, and so she figured out that since that didn't work with the case against me for breach of deed restriction, that she was going to use the city to pursue me. That's what she's doing. And that's
which you can then sue her for harassment for, as long as you can prove it.
Yeah. Harassment is not that easy.
Well, the harassment would be easy to show after all those complaints.
Harassment and stalking, yes.
Stalking, use the videos, use it wherever you can't. Do something, because this might be your only shot. If you don't at least get it on the record at some point.
Yeah, I was going to do that, but if you look at the O'Connors and look at the requirements to reprove stalking or harassment, I can't. I mean, harassment, I probably can. Stalking, I can't.
Jane,
What?
the issue is not whether or not you can prove it.
Well, I mean, I don't have the
You make the allegation, and the cops are the ones that are supposed to investigate and prove it.
Yeah.
All you have to do is give them enough reason to look.
Document everything.
It has been, and they've been out here 100 times, and all the way they see us now as individuals are two ladies who are always fighting. They don't take anything serious. It's two ladies.
Do they view the videos?
They've seen the video, but here's the thing: they convicted me on evidence of her video and not seeing the crime in person. But yet,
They don't have to see the crime in person if they have video of it, Jane.
On trespass,
do I have to tell you that?
On trespass, they do. Irving has a trespass thing. I can show it to you right now. That says they have to see it, and they have to be able to tell the person to get off the property. They have to see it in person.
Well, they have to have proof that you were told not to be on the property.
But they also have to see it. Every time I've called them, try to get them to stop having her put trespass and put her trash in my yard, they say they have to see it in person, and that's what their trespass warning thing is about. They have a certain trespass warning thing. It might not be like that in all cities.
Hey, Jane, didn't they, when she came on your property and stamped on the work you were doing on your yard, and
she tried to sue. She made a false allegation of assault, said I assaulted her.
Right. They reviewed the video and never acted upon it in either one's favor, correct?
No, they didn't, because yeah, that's right. They were going to act upon it until I showed them the video that you slowed down for me that showed her actually assaulting me first.
Right.
You know?
And you defending yourself.
Yeah, they didn't pursue it after that. So,
but they never tried to prosecute her for it. Video evidence.
Prosecuted for anything. Yeah.
So why not just make a home video with all the recordings of her just losing her shit and play that for the court?
Well,
Yeah.
she needs a wellness check. She needs to be treated. She's not well.
I had one called a psychopath. That's why I had that video, but
yeah.
But I need to create another. I've got so many videos. But see, here's the thing about these cases also too. Those videos won't be evidence after they're a certain age, right, Eddie?
No, they'll always be evidence. The question is whether or not they can use them as evidence.
Okay, because a lot of those videos that Julie saw are from a period that was before the last 2 years. In other words.
Yeah, but the thing is, there's a history when we work with behavioral health analysis, there are doctors, a psychiatrist, or whatever. They look at those histories, a long history.
Oh, see, I can
You see what I'd do if I was Jane, this is how I would handle this situation. I would take all these collective videos, I would set it to punk rock music and all these little flashy cartoon changeovers and shit with videos of her staying out there screeching in tune with the lyrics of the music. And I'd put that motherfucker on YouTube with all of her information.
Hell yeah.
Well, wait a minute.
And then I would email her the link.
Yeah.
And watch her stroke out and be done with it.
That could easily be arranged, Jane.
You would sue me for defamation, but I mean, Julie, I can see
what is defamation? There is you're saying absolutely nothing in the video.
Oh,
You're
yeah.
playing music.
You're right.
Yeah, I could do that.
And all it's
easily.
got is her likeness screaming at your camera or at you or whatever. That's all. That can't be defamation when it's based on truth.
But some of it she is screaming. Some of it she is screaming.
We don't care. You don't need her screaming. You just need her standing there with her mouth wide open, flailing her arms.
Yeah.
And bruising her gums. That's all you need.
Creepy neighbor, peeping Tom, psycho. It's not normal.
No,
Hey,
but
Jane,
don't
tell
put
them what you named
anything
your
like that in the
Wi-Fi
video. Don't put anything in that being descriptive, because that could be perceived.
Oh no, you won't have to, but it needs to be documented. Documentation can save you later on.
I told Jane already, her best bet would be to go around and talk to the other neighbors and see if this lady's causing issues with any of the rest of them as well.
Oh yeah, she doesn't do that.
Yeah, I think there is history of that, right, Jane?
No, but those people
But that's the point, Jane. If you can show that she doesn't treat any other neighbor this way, then that becomes a specific case of targeting and stalking. So you need to make it irrefutable that this is what's happening, and I deserve your protection just like all the protection y'all are giving her for making false claims. I'm making truthful claims and you're doing nothing. Well, you can use all your old videos to show a history, Jane. Julie's absolutely right about that. And then the next time she does something that's directly actionable that you've got fresh evidence of, then you can take that entire video collection, file a lawsuit against her, take her to court and get a judgment and make it where if she sets foot on your property ever again, she's going to fucking jail. If she throws anything on your property ever again, she's going to fucking jail. If she files a harassment complaint against you, she's going to fucking jail. It's her recording. She's the owner of the video, so she doesn't need anything beyond that.
Yeah, but
the only thing she would have to authenticate is the date and time and location where it was taken, and that's up to her to do.
Right. If she had them off for compilation of the videos,
that part wouldn't be evidence. It would be the individual videos.
She can give them copies of the videos.
Right.
And the only time they don't have to use them as evidence of the crime right then and there. They would need her to testify to what the copies are. They can use a copy of the video as evidence. They just need someone in court that can testify where that copy came from, and that it's a valid, true copy of the original.
Gotcha.
Eddie, even if the police won't do anything, can't Jane go down to a courthouse herself and file those charges herself?
Yes.
I have well, I did file one, and then I think she did get prosecuted on it, but I don't know how I found that out, but because she trashed my patio. I woke up one morning and she was out there, and I heard scraping noise on my patio door. I go outside and she's shoveling dirt and water and debris off her balcony onto my patio.
I'd be setting up an electric fence.
And this is what started
low to the ground.
This is what started all of this, though, because I tried to get the prosecutor to press charges on her, and Candace Chapman at the time, she said no because something about the officer didn't witness it, what she said, and so I wrote a bar grievance on her, and that's the reason why they ended up pursuing the cat trap charge on me, because I wrote a bar grievance on that her attorney that she's not there anymore now, but she
retaliation.
Bar grieve them again.
Yeah. So
well, that's not actually a provable fact, though, right? It's
I can't prove that that's the reason why, but I know that's the reason why. You know, I mean, that's the whole reason they started pursuing me, and that's what I'm saying. Eddie, it's not just the fact she thinks I'm an easy mark, but because I've already pissed them off right off the get-go.
Well, this case has nothing to do with whether or not you have a case to sue her on something else.
Oh yeah, but that wouldn't be in this court. So
no, it wouldn't.
Well, in this case, it's unequal protection under the law and unequal.
Equal application of the law and equal access to the courts, Jane. Those are two very relevant issues in your case that you need to be pointing out.
Right, and also with the neighbor.
But you're entitled to equal protection of the law just as much as you're entitled to equal application of it.
Exactly. And that's what I'm not doing.
Well, the question then becomes, are you able to sue the cops for not doing their job and thus allowing the harassment to continue? That's a different issue.
Yeah,
but you definitely have the issue of harassment you can act on. You just have to do it.
Yeah. Well, I got to
speaking of cops.
I mean, the thing is about that in a civil court, just because I get a judgment doesn't stop anything. And
it doesn't. But it does put a stair step in front of her that she's got to walk up. And if she does, then you've got grounds to go back to the court and say she violated your order.
So now it has to
because one of the things you're going to ask for in your suit is an injunction against her from any future harassment or a protective order or a permanent protective order, something of that nature.
Yeah, because the court won't, just because they they award me damages.
Correct. That won't stop anything. But part of your damages and award needs to be a demand for a permanent injunction or protective order barring her from interacting with you or entering your property.
Right.
And if the court awards that and she violates that, her old ass will be rotting in jail somewhere.
Well, I hope so. That's the dream.
Well, then make the dream a reality by doing it right. Get
Have a
your
chance.
evidence, file your suit, and get rolling.
Anyway.
But it is absolutely imperative that you, if she approaches to your property, you record it, but you do not interact with her, even if that means going back in your house and continuing to record her. Go in your house, let her do whatever she's going to do, and get her ass sent to jail for it.
Yeah, I gotta get the freaking body cam that actually works because my one does not. It won't stay charged. I mean, it stays charged, but it won't.
Well, again, you need cameras around your property that have audio recording capability as well as one you can have on you.
Yeah.
So that Wise cam that I just posted that has audio, video tracking.
Yeah, but you got, as someone's saying, you got to be real careful about the brands you get because they don't always work.
Yeah, I know I've used Wise before. I think I have, but now if it's is it not? It's wireless though, right?
Well, like I say, if you will get you a good game camera, it doesn't have to be wireless, but it can be. But if you get one with wireless, it's more expensive. But if you get one that locally records to an SD card and you make sure it is well out of her reach to see it or destroy it, but it can still see what you need to see when you need it seen, that camera that can record on a local SD is your best bet. It's way less expensive when it's not wireless. But if it is wireless, that just means you can access it and see what it's seen and copy the information off the SD card without having to climb up a ladder to get it.
Yeah, I can record on the SD card on my Blink cameras, but it's also in the cloud. But this doesn't look like a game camera. This looks like a inside camera.
Well, this is an indoor-outdoor camera. This is an indoor-outdoor camera.
Like a game camera, right? A game camera.
Well, a game camera, it can be one that does any of this stuff.
Yeah,
there are game cameras, but the more features like that you add, the more expensive the camera gets.
Yeah.
You're looking at a couple of $100 per camera for a really good wireless one that records locally and wirelessly.
The wireless
allows you to access it.
You know, because the wireless settings are like you can set it to re-trigger and all this kind of stuff. But when it's if it's refreshing or it hasn't had a chance to get back to start again or whatever, then you miss a lot because of the fact that it misses that part of the video.
Well, that's the only downside of a game camera is it doesn't do extended recordings. It does snapshot recordings.
Yeah.
It's motion sensitive and it records for X amount of time. And you get to choose how long, but it's usually not more than a few minutes. And that's so it doesn't fill up your SD card so fast.
Yeah, and so now I have unlimited cloud storage and I'm paying nothing for it since it was grandfathered in on my Blink. And I can record.
Okay, then just get you some additional Blink cameras and feed them all.
Well, I can record up to like 45 seconds or whatever. But the problem is she knows what the recording time is. She used to have these. And so what she'll do is she'll pull up and stop and she'll wait the appropriate time to come out and do her thing. She knows that there's a time that.
Well, that's why having alternatives is also a good idea.
Having a couple, 3 different ones, yeah.
Hey, Eddie, can I ask a question? I got to go to bed. We're talking about cops and going after them later on and for malicious prosecution or whatever. I still struggle with this verbiage. You can go after a cop easily for malicious prosecution, but they're not the prosecutor, and you can't go after a prosecutor for malicious prosecution.
They're the false accuser. That's what makes it malicious prosecution.
Right.
The prosecutor, it's when the prosecutor knows they don't have a case and they proceed anyway that you stand a good chance of going after the prosecutor. But it's when the cop fabricates evidence and makes the allegation that it makes the cop guilty of malicious prosecution.
Okay. So in this event, because you've talked about city, Jane's going to have no problem going after the city prosecutor because there's no immunity under Imbler in that case, etc. But the state prosecutor or the county prosecutor, what changes there? Because are they elected or are they appointed on the county level?
They're constitutional officers almost always, and they are also they're responsible for the bigger crimes, actual crimes, not petty crimes.
Well,
and what the fear is with them is that they will be chilled in their effort to act as a prosecutor if they can be held accountable for prosecuting people. That's the idea. Okay? It's a bad idea as far as the way they do it. Prosecutors should not be immune from suit when what the prosecutor did was knowing and willfully unlawful and malicious.
But they still are? But they are? Is that what you're saying?
It's when they're intentionally wrong, knowingly wrong.
Yeah.
They hide evidence. They destroy evidence. They withhold evidence. They fabricate it. Any of those things, they make it up as they go along to win. Those are the people that should be able to be sued and held accountable.
And we can, right? And they
Well, that depends. If you want to go to jail for 25 years and find out later that the prosecutor framed you, and then you have a case.
Oh my God.
Okay. But the issue there is that's why it's done that way.
So I'm trying to understand this county/state prosecutor, because in the county they have a prosecutor's
They're
office.
constitutionally created and elected officials. Okay.
But what about their subordinates who are also the DAs?
Same deal. They're covered by the same immunity.
Okay.
All right. However, the city attorney has no such immunity. They're appointed city employees. They're not prosecutors. They have no legitimate authority under the Constitution to prosecute in the name of the state. At least not in Texas, they don't. And so here, they think they probably believe they have prosecutorial immunity, but they don't. Okay. And there's no way they can get it.
Any guidance for me to go down a rabbit hole and find out how these first appearance centers, how they are getting away with this shit? Because that's my only
getting away with.
Well,
what state
pushing,
are you in?
I'm in Colorado.
Okay, so in Colorado, what is the rule of the criminal procedure rules on how things have to be done, and are they following them? And well, then again, the question becomes, if they are following them, are the rules themselves constitutionally correct and due process correct? That's the other question.
I have found nothing that talks about a first appearance. When you talk about first appearance, it's before. It actually has to do with being before a judge in the court. These are the first appearance. Like that's the language I've seen in the case law and the laws. I have found nothing.
There's two ways to judge a first appearance. A first appearance is normally for a probable cause determination. That's supposed to be the first thing that's done in any case.
Correct.
Okay? The next thing is first appearance after an actual charge has been filed or an indictment handed down, and you are now going to court for the actual charges after probable cause has been found. So it depends upon how the rules are defining a first appearance versus a probable cause.
Well, in Colorado, misdemeanors do not get probable cause. You get an arraignment, and it's very rare.
That's a due process violation. If it's a misdemeanor, it's a crime. Every crime requires probable cause, especially if you've been arrested without a warrant. If they made a warrantless seizure for a misdemeanor, then there has to be a probable cause determination that the arrest itself was valid without a warrant. The cop doesn't get to make that decision. The prosecutor does not get to make that decision. Only a judge can make that decision.
Yep. And it says that you're to be brought before it doesn't say magistrate. It says the nearest court or judge, something like that. It actually says that.
Here it says the nearest magistrate.
Right.
But Colorado that means a judge of an actual, magistrate of an actual court.
Right.
It has to be a true judicial magistrate.
Right. So again, I'm trying to find because I'm going to try to do a little investigative work and call up to this first appearance center and say, hey, where's the law that says I have to come to this damn meeting? Or who even establishes you as something? And of course, they're probably going to hang up. So I'm trying to figure out how this process became the image of something that's obviously not
the only way
legitimate.
You're going to find that is to first and foremost understand the rules they're supposed to be playing by, which means you've got to know the Code of Criminal Procedure backwards and forwards. At least the one covering the specific processes you're talking about. Now,
That's
that may
the
be
issue.
only certain chapters, or that may be an entire title. For instance, here in Texas, you damn well better know pretty much everything in Title 1. If you don't know Title 1, you don't know criminal procedure, period. And that's a lot of chapters. They're not huge chapters in most of them, but there's still a lot of them.
Okay. Well, I'm suspecting what they've done is they've taken the normal code of criminal procedure and created this mirage of another process that has some similar aspects, but it's not a legitimate process. That's
Correct,
why it
and they've done the
exist.
exact same thing here, and that's exactly the stuff that Randy and I go after on a regular basis.
And they've done that here in Indiana too. The reason they do that is because they've become complacent because they haven't had enough people challenge them on it.
Yeah, nobody's been pushing back because the attorneys all played along with it because it simplified their court appearances.
They got
made it easy on them.
Yep.
And they don't want to vote. You know, they don't want to cause the state to lose money.
But I've got a federal judge. Quoting Imbler, which is this case that talks about prosecutorial immunity, and he's trying to blanket that. So I'm trying to back them into a corner. Hey, you know, I think I mentioned the judge. Where does this relate to this process on the county level? And of course, they don't want to touch it. So
well, of course,
I'm trying
not,
to find,
because they'll be stepping on somebody else's toes.
Yep.
But you need to do what Randy and I have done. I sat down and I made a roadmap of the statutes. For instance, we wanted to see how the law dealt with complaints. So we searched the Code of Criminal Procedure for the word complaint. And we cross-referenced every statute in the Code of Criminal Procedure that talked about a complaint till we understood how those statutes interacted. And they do interact. None of them stand by themselves. They all talk about something that must occur in this circumstance or condition, but that correlates to something else somewhere else that says this is what you must be doing in this process. And suddenly what's written over here is exactly the same thing you're supposed to be doing right here. And you're not doing it that way. Why? And then we expand out, okay? Now we go to the Transportation Code. We see where the Transportation Code talks about a complaint. Now I can take every part of the Transportation Code that says an officer can do this, this must occur, and I can now match those statutes to exactly the particular part of the process that's in the Code of Criminal Procedure they're supposed to be complying with. Now I can say right here where it says an officer can arrest without warrant in the Transportation Code, that is specifically referencing 14.06 or 14.02 of the Code of Criminal Procedure. And that leads us into this section under 16 of Chapter 16 of the Code of Criminal Procedure. I can do all of that now because I mapped it all together. I found out where everything was. I cross-referenced it, I indexed it, and then I said, now, this part is talking about this part right here, this part's talking about that part right there, and you guys aren't doing any of these parts. Therefore, you're not following the criminal procedure prescribed by law. Somebody better fucking tell me why.
And then they changed it.
That's exactly what happened. They went back and tried to fix it.
Yeah, they went back and changed it. No, I mean, I'm saying they changed the law so that so they could disprove something that you were saying or whatever.
Okay, I'll dig a little deeper. I really would like to find and put them on the hook and say, we don't know what statute allows us to do this, or here it is.
Right, because in most cases there is no statute. What they've done is they've taken the process, whether it was right or wrong, and figured out a way that they wanted to streamline it, to make it easier for them to process more people faster.
Yes.
That's what the whole system is there for. It's a fucking cattle auction.
Yeah.
Okay?
And they rely on people to not know the law and not know how to defend themselves.
What you've got to do is be the steer that won't leave the fucking chute.
Yeah, they don't like you either doing that, that's for sure.
Well, if you could make $340 just by walking in and going, we plead guilty, Judge,
Yep.
and then leave.
And then the judge asks them, did they defend you properly? And they'll all say, yeah. I'll be saying, no, they didn't. But, I can't say it. But as a person in the audience waiting my turn, no. There's no effing way they defended you. You just wasted your time and your efforts and money.
And quite probably your money. First off, I hope everybody appreciates what we learned in class tonight and that you took it to heart and understand why this is the way you need to think about things. Okay? You've got to get your head wrapped around how this works. Not how you want it to work, not how you believe it should work, but how it actually works. And the only way you do that is, one, you have to understand how to read a law and tear it apart, which I gave you an example of how to break it down. Okay? You have to figure out how to talk, what to say, and how to say it. Okay? Let me give you an example. This is Jane's opening statement here. I just want to go over this real quick because we're an hour past. This is Jane's opening statement. I want to go through just a couple of these, and I want you to understand why this is, for the most part, not the best approach. This is why I gave y'all that link to that article. You have to get the court or the jury or both looking at you with goodwill. Okay? Not as a problem child. Not as a complainer. Not as a victim. But someone who has been wrong that is seeking justice and seeking it for the right reason. Okay? So, Judge, this case is about living in a society in close proximity with others and amounts to nothing more than two neighbors who do not get along. Why is that not a good opening statement?
It's the truth, but it might not be good because it's not relevant.
No, because you've accepted half the blame with this statement, Jane.
Contributory negligence.
Yeah.
Okay? You've taken half the blame right off the bat with this statement.
Okay. Yeah, you're right. Okay.
Okay?
Right.
All right, ladies and gentlemen of the jury or judge, this is a case that revolves around nothing more than a vindictive, hateful neighbor. That's it.
Okay. Like the city's attorney complaint when it says vendetta against the respondent.
Okay? The city's attorney's complaining witness has a vendetta against the respondent, and this is what will come out of this trial. No, it's not.
Well,
that will never be the issue of this trial.
I mean,
that's ultimately why you're here, but it's not the issue of the trial. And therefore, all you're going to say is your introductory line of, here's why we're here truly, and then we'll get to the rest of it. That's it. So the second question, don't even bother.
Okay.
Now, the city attorney would have you believe that the respondent has committed a crime against the laws of this state or violated a city ordinance. First off, we don't need all that. Okay? The city attorney is accusing me of violating
that was
a city... What?
That's Jerry Spence, the way he talks. Anyway, go ahead.
I understand that's how he would talk, but he'd be talking about it in a much different way. Okay? The city attorney is going to try to convince you I violated a city ordinance. The city attorney will present evidence to try and prove an offense, but the evidence fails at every element. No.
It does, doesn't it?
Jane, if they have evidence, you're cooked.
Okay,
the issue here in the whole case is they don't have any fucking evidence.
Okay, yeah, you're right.
Okay? The city attorney will present all kinds of testimony that does not have any supporting evidence of any kind.
Okay.
Wouldn't a better term be lead you to believe?
You can figure out the best way to word it. The first way is to figure out how to even ask the question to start with. You can always refine it after the fact. Okay? The city attorney will attempt to present testimony alleging an offense for which they have absolutely no evidence in support. That's another way to say it. But it all amounts to the same thing. No fucking evidence. Not that they're going to present evidence, because they don't have any. So don't say it in a way that makes it look, their presentation, right off the bat, you've made their presentation look legitimate.
Oh, yeah.
Could you say that they're going to present testimony that does not support?
No, that is unsupported by any evidence.
Right on.
It is entirely speculative. It is entirely someone's opinion, but it is not evidence. Okay? It's completely subjective opinion. Judge, the city attorney cannot prove any single elements of this offense, okay, because no offense occurred. Judge, the city attorney will provide the court with no evidence of an offense because no offense occurred.
Okay.
The city attorney must prove one of three elements of the alleged offense and must prove it beyond a reasonable doubt. No. There are not three elements of the offense. There are three separate offenses.
Okay, one of three elements.
No. The city attorney must prove at least one of three potential nuisance violations.
Okay.
Not elements. The elements are something that makes up that violation. But there are three potential violations down there, aren't there?
Okay.
They have to prove
E1,
all of the
E2, or
elements.
E3, right?
Aren't those elements of the...
No, Jane. They are not elements. The elements are 11 animals congregated in a single location at the same time. Those are the individual elements.
Okay.
But all of them together are the offense.
Okay.
The city attorney must prove two predicate facts and at least one of three possible offenses.
Okay.
But they will offer no evidence in support of any of the predicate facts or any of the offenses or any element of those offenses. You get it?
Yeah.
So, that's all I need to go through on this to show you why this will not do as an opening statement.
All right, well. I like the second to the last one.
This case must be proven beyond a reasonable doubt, but there will be no doubt before the closing of this case that the respondent is innocent. That's not a statement.
That's a statement? What do you mean it's not a statement?
Okay. The state bears the burden of proof beyond a reasonable doubt, but the state lacks supporting evidence in order to remove doubt. And by the closing of this case and the state's lack of evidence, you will have no choice but to find the defendant innocent.
Okay.
That's how Jerry Spence would say it.
Yeah, I know. He tells a story. I recorded his audible.
Okay. So, you get the idea, guys? So,
yes.
We will try a mock trial next class, next week. That's the first free class of the month. I will send out the links for that probably sometime over the weekend. Since it's the free class, I send those out early. So feel free to come back and participate. However, we will choose different people to play different parts. So try to be ready to understand what has to be proven here, which means you need to read the ordinance. You need to read this, go back and review everything we've talked about at the beginning of this class via the video. Okay? Well, anybody that shows up for class is going to get asked if they're willing to play a part. And you can volunteer all you want to if you do. Just make sure you're prepared, because I can't guarantee which part you're going to play. Okay? But in any case, y'all get prepared for that. All right? I don't want to have to spend a lot of time re-going over shit next class. Be prepared, people. Good night. Have a good weekend, and I will see y'all next week.